All rise.
The Kosovo Specialist Chambers is now in session.
Be seated. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Gucati and Haradinaj.
Thank you. Good morning and welcome, everyone. First, we'll take the appearances. Mr. Pach.
Good morning, Your Honor, and to everyone here and joining us remotely. For the SBO today, we have Valeria Bolici and Matt Halling, prosecutors, Lena Peterson, case and evidence manager, Ruth Delpino Blyerfeld, legal intern, and I'm James Pach, associate prosecutor.
Thank you, Mr. Pach. Mr. Rees.
Your Honour, I appear on behalf of Haradini Gucati. I'm assisted by co-counsel Mr. Hugh Bowden and Ms. Eleanor Stevenson. Also assisted by Ms. Faye Wigmore, Mr. Joseph Bowden and Mr. Remy Hanlai.
Thank you. Mr. Cadman.
Good morning, Your Honours. I appear on behalf of Mr. Nassim Haradinaj, who appears in person today. I'm assisted by Mr. Solomon, Ms. Rolio and Ms. Frivet.
Thank you, Mr. Cadman. I also note that Mr. Gucati and Mr. Haradinaj are both present in court. I note that Judge Mitro is once again participating via Zoom, and Mr. Rees, we welcome you back. Prior to starting with the testimony of the first witness, there are a few housekeeping matters to deal with, starting with the timeline for the next detention review. Last week, Mr. Cadman, you told us that you and Mr. Halling had agreed to request, and I quote from the transcript, a 10-day deferral of the panel making that decision in order to allow the appeals chamber to make a ruling as they have done in case 06. Mr. Halling confirmed this. The Gucati defense stated that it would be content with the proposed amended schedule. Now, in case 6, the pretrial judge varied the time limit for defense to provide their submissions on detention no later than 10 days after the notification of the Court of Appeals panel decision. The panel also notes that in that case, the defense filed their submissions first and the SPO responds, while in our case, the SPO goes first. I also note that if your request is that the panel defers its decision with only 10 days, that means your submissions will have to come before us within those 10 days, and in fact, within probably a week from the appeal decision. So we need some clarification on what exactly you're requesting.
Your Honour, the question was put to me by Mr. Halling because of the decision taken in case 06. I indicated that I had no objections following the same course of action. I understand that the way in which detention is dealt with in this case is different, as you've already indicated. I think the position is that it is difficult for us to put in those submissions until such time as the appeals panel has made their decision. If it's 7 days, if it's 10 days, we're ready to proceed. We're just awaiting the decision of the appeals panel.
Microphone, please.
But then the SPO will make their report within 10 days, and then how much time do you need?
Well, Your Honour, if the SBO is going to put in their submissions within 10 days, I would say we would require limited time. I wouldn't ask for much more than 3 or 4 days.
Okay. Agreed?
Yes, Your Honour.
All right. We'll enter an order later today. I'm sorry, I didn't ask the Gucati defense about that. Is there any objection to that process? I know you
Well,
did not
I'm
appeal.
I'm slightly confused about what is being proposed.
Okay.
I understand, in general, the concern that with a appeal against detention outstanding, there's an element of one doesn't want the decision of the Court of Appeal being prejudged by a further decision on detention in the interim. But saying that, I am concerned about the mandatory period for a review of Mr. Guzzati's detention slipping in the meantime. There would be less concern if we had some indication as to the time frame within which the Court of Appeals panel is likely to provide a decision on the appeal, and if, of course, that was within the period or would precede the next mandatory review, or indeed be at least close to it, then I wouldn't have any concern, and I would simply be content to follow the proposals from the SPO and Mr. Haradinaj's team. But I would be concerned if having an open-ended period, agreeing to postpone any further reviews of Mr. Guzzati's detention without any indication as to how long that's going to take. And of course you didn't appeal the original decision. We did.
Microphone.
Pushing the button wrong.
We didn't, although of course there is a corollary effect of the appeal being made by Mr. Haradinaj, which, if it was successful, would undoubtedly have an impact upon the detention review for Mr. Guzzati.
Have you discussed this at all with the prosecution?
No.
Perhaps you should do that, and then get back to us and we will make a ruling. Is that okay, Mr. Potch?
That would be okay, Your Honor. I just would like to point out that our understanding is that the last time this was discussed in open court, the Guzzati defense actually agreed to this procedure.
Yeah.
So now we seem to be revisiting something that was agreed on. But yes, we can discuss if that's necessary.
Because Mr. Reese wasn't here at that time, and you've asked permission to bring the matter up, I would suggest you talk it over with the prosecution. Perhaps there's a solution.
And I'm not raising an objection,
I know.
and nor am I going back behind what was said last week. I'm simply raising the concern that we don't want this to be an open-ended process, which defers a further detention review for Mr. Guzzati without any indication as to how long it's going to be until there is a further review.
Unfortunately, we don't have any control over that situation, so I think your point is well raised, that it needs to be discussed.
Okay, thank you.
So if you will all get back to me with a submission perhaps by Friday?
Yes, we'll do
Okay.
that, Your Honor.
All right, thank you. Moving on to the second housekeeping matter, the registry informed us that the second expert witness, Mr. Reed, will be available to testify via Zoom on Monday, the 24th of January, from 8 a.m. until noon. So once again, we will be opening court for that session at 8 o'clock a.m. on the 24th. We are grateful for the efforts of the registry and the cooperation of the Australian authorities. I now turn to the Haradini application requesting the panel to authorize the advanced disclosure of a number of documents to the second expert witness, Mr. Reed, that is filing F-524. Since the witness is due to testify on Monday, 24 January at 8 a.m., the panel will now issue a short oral order with written reasons to follow. On January 18th, the Haradini defense filed its application to the expert witness prior to his testimony. On January 20th, further to a reduced time limit, the SPO responded. The panel notes that the Haradini defense requests the disclosure of the following material: all unredacted transcripts and all declarations of SPO witness Pumper, Jukic, and Moberg, all declarations of an SPO investigator, 4 handover forms relating to the seizure or receipt of batches, and a video recording of the SPO search conducted 25 September 2020 at the WVA premises. The panel considers this request to be untimely, unsubstantiated, and improper. Untimely because the Haradini defense has had access to the handover notes, all declarations of witness 4841, and the video recording of the search since the pretrial stage. So it could have requested this disclosure before the report was prepared. The confidential transcripts have been available at the end of each day of testimony. Also, the testimony of witness 4841 was finalized on 26 October 2021. The expert report was filed on 9 November 2021. The Haradini defense never explained why the material requested now were not flagged before the report was filed, or why a request to amend the report has not been filed shortly after its submission. The Haradini defense could have also requested the disclosure as soon as it was notified to the Court of Appeals decision. The application is also unsubstantiated because no reasons are provided for this late request. It is further improper because it inappropriately seeks to expand the scope of the proposed expert evidence beyond the scope of the report and beyond what has been authorized by the Court of Appeals panel. These reasons are further explained in the decision which will follow. That being said, this panel wants to give the full effect to the decision of the Court of Appeals panel, which is to allow the evidence of Mr. Reed for the limited purpose of challenging the evidence of SPO witness 4841. The panel also wants to guarantee that the right of the accused to a fair trial is not negatively affected by the belated nature of this application. So the panel reviewed the merits of this request and decides as follows. The transcripts and declaration of witnesses 4842 and 4876, the declarations of SPO investigator, and the search video of 25 September 2020 fall outside the scope of Mr. Reed's report and outside the scope of the testimony as allowed by the Court of Appeals panel, so their disclosure is denied. The handover forms are available in public redacted versions, and 3 of them have already been shared with the witness. The panel sees no good cause in disclosing the confidential versions, and the defense has provided no cogent reasons for it. All public transcripts of the testimony of witness 4841 have been available on the court's website since the 11th of November of 2021, so the panel is at a loss in understanding how these could not have been provided to the witness. As for the confidential unredacted transcripts, the panel found only one private session on 19 October 2021 that could be relevant to and falls within the scope of the expert report. The panel therefore directs the registry to disclose to the witness by end of today the confidential transcript of 19 October 2021 under the following conditions. The private session on pages 953 to 961 should be unredacted, save for a name in line 21 of page 953. All other private sessions in that transcript should be redacted. The witness is ordered to maintain the confidentiality of the disclosed portion of the transcript, and counsel for Mr. Haradini is ordered to inform him accordingly. As for the declarations of witness 4841, the panel found that some of the admitted declarations are partly relevant to and within the scope of the expert report. Nonetheless, the panel found no good cause for disclosing the confidential versions of these declarations, and the defense has offered no cogent reasons for it. It is noted, however, that the panel already approved proposed redactions to the public versions of these declarations, which are due to be uploaded on 31 January of this year. For these reasons, the panel orders the SBO to provide the Haradini defense by 8 p.m. today the following declarations under the following conditions. Paragraphs 1 to 12 and 19 to 35 of P86, public redacted version. P88 in full, this one is public. Paragraphs 1 to 13 of P89, public redacted version. P90 and the first page of Annexes 1 and 3, all in public redacted version. P91 and the first page of Annex 1, both in public redacted version. The Haradini defense is ordered to transmit these documents to the witness by 9 p.m. today, The Hague time. The panel approves this limited disclosure with the following strict directions. The witness will not be allowed to give evidence in his examination in chief on any matter that goes beyond the scope of paragraphs 9 to 25, 27, 29, and 31 of his report, indicated by the Court of Appeals panel as permissible for the purpose of challenging the testimony of witness 4841. Any line of questioning arising from the disclosed material will be limited to eliciting explanations of the analysis provided in the aforementioned paragraphs. The witness will be directed to answer such questions with a view to explaining, but not exceeding, the analysis he provided in the aforementioned paragraphs of his report. The witness will also be directed to be mindful of not disclosing confidential matters in public hearings. Any questions regarding the disclosed confidential transcript should focus on the procedures described therein in view of the analysis provided in the report and should not reveal confidential information. In any event, the Haradini defense is ordered to notify the panel and the parties by Sunday, January 23rd, 2022 at 10 a.m. Dutch time of any line of questioning arising from the disclosed material and any clarifications the witness provided upon reading the disclosed material. Failure to do so could lead to the panel's refusal to allow any such questions during the witness's testimony. Depending on the aforementioned notice from the Haradini defense or the scope of the direct examination, the SBO is invited to request more preparation time for the uploading of its presentation queue or cross-examination, but with a view to finalizing the testimony on 28 January. This concludes this oral order. All right, before we begin, Mr. Cadman and Mr. Bowden, before Ms. Myers begins, I should say, Judge Metro has some questions for you about the case so far as it pertains to the proposed evidence of Ms. Myers. Judge Metro, the floor is yours.
Thank you, Judge Smith, and good morning to all in the courtroom. Before Ms. Myers is brought in, I would like to seek some clarifications from defense counsel, and perhaps first to Mr. Rees or Mr. Bowden. Am I to understand that the claim of whistleblowing is part only of the Haradini case, or is it also a part of your case, the Gucati case?
Honor, the public interest issue is very much a live part of the defence of Mr. Gucati. We await to hear the evidence of Ms. Myers with interest, and we take the view, at this stage at least, that we anticipate that that evidence will be relevant to the defence of Mr. Gucati. The public interest matters as we have described them, and we anticipate that we will incorporate and make references to Ms. Myers' evidence in our final trial brief and closing statements. We anticipate evidence that will be called this morning, that will be evidence in the case as a whole, and we will be making submissions in relation to the evidence as a whole, including Ms. Myers' evidence in due course. I hope that assists, Your Honour.
It does, and I'm grateful, Mr. Rees. Mr. Cadman, now, we do understand that it is a part of your case that your client, Mr. Haradini, acted as a whistleblower. Is that correct?
That is correct.
And is it also the case that the legal basis upon which you rely for that claim is made up of the law number 06L085 of 18 December 2018 and the European Convention of Human Rights? Is that the basis on which you rely for that claim?
That is correct.
Now, turning first briefly to the issue of the European Convention of Human Rights, and as you know, according to the case law of the court, freedom of expression carries with it certain duties and responsibilities. And any person who chooses to disclose information must, and I quote, carefully verify to the extent permitted by the circumstances that it is accurate and reliable. Now, what I want to understand from you is whether it is indeed your case that your client took steps before publicizing that information to ensure that the information in question was accurate and reliable, consistent with the jurisprudence of the court.
Well, Your Honour, obviously these are certain points that Ms. Myers will be able to comment upon to the extent that that is required and what steps need to be taken to verify the accuracy of the information. Your Honour will have heard Mr. Haradinaj's evidence and Mr. Gucati's evidence to the extent as to whether they considered the information to be accurate and reliable. But of course, these are matters that are going to be put to the witness in order for her to determine or to set out what are the requirements that come from the various different rulings that she refers to in her report. But certainly, as you've heard from Mr. Haradinaj, the steps that were taken, there was obviously a very quick review of the material. They had requested verification. They never received that verification from the SBO as to the reliability or authenticity of that material. But of course, that is one of the points that I will be putting to Ms. Myers as to the extent to which an individual is required to carry out a verification process before making public that information.
Well, just maybe a clarification. I'm asking what your case is, not what the law is, which you can, of course, discuss with Ms. Myers when she's here. What I want to understand is whether it is part of your case that your client took steps consistent with the jurisprudence of the court to verify that the information in question was accurate and reliable. Is that part of your case? In other words, your case is consistent, you say, with the jurisprudence of the court on that point?
We say it's consistent with the jurisprudence. We say that it falls squarely within those principles set out, and to the extent that they were able to verify that information, that is the steps that were taken prior to the publication.
And one more question, if I may, about the law of 18 December 2018. And again, of course, you're aware of that. That's Article 314 of that law defines disclosure for the purpose of the law as making information public. Now, what I want to clarify is whether you accept that your client made the imputed information public, again, consistent with that piece of legislation.
Again, as you will have heard from Mr. Haradinaj's evidence, and this was one of the issues that came up during cross-examination as to making something public or publishing information. The point that was made in Mr. Haradinaj's evidence was that by making that available during the press conferences, that information has been made public.
Thank you, Mr. Cannon. No further question. Thank you, Judge Smith.
All right, now we're ready to start with the expert witness, number 1252, Miss Anna Myers. Madam Usher, would you please bring the witness in? Please put on your headset, Ms. Myers. Good afternoon, Ms. Myers. We will start now with your testimony. The court usher will first provide you with the text of the solemn declaration that you are asked to take pursuant to Rule 149, Paragraph 5 of the rules. Please proceed and read it aloud.
Thank you. Conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will perform my expert analysis conscientiously and to the best of my knowledge, and that I will state my findings and opinion accurately and completely.
You can be seated.
Thank you.
I have some preliminary material first, Mr. Cadman. Ms. Myers, as you may know, we are hoping to hear your testimony by the end of today. If we are not finished by the end of the day, we will hear the rest of your testimony on January 24th in the afternoon at starting at 2:30. Now, the counsel for Mr. Haradini, Mr. Cadman, will go first in asking you questions. Once he's done, the Gucati defense, seated over here, may have some questions for you. Then it will be the prosecution's turn to cross-examine you, and the members of the panel may have some questions as well. The testimony of the estimate of Mr. Cadman for your length of examination is 2 hours. The Gucati defense estimate is 1 hour, and the SBO estimate is up to 4 hours. The panel may allow redirect examination as well if conditions for it are met. Please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask counsel to clarify or repeat the question. Also, speak into the microphone and wait a few seconds after the question to allow the translator to keep up with your testimony. While you are giving evidence in this court, you are not allowed to discuss with anyone the content of your testimony. If any person asks you questions about your testimony, please let us know. Please also base your answers on your experience and expertise and respond to questions within the limits set by this panel. We take it that the counsel for Mr. Haradini has informed you of the following. The panel will not allow answers on paragraphs 23 to 25, 32, the second and last sentences of 34, paragraph 36, the second sentence, and paragraph 40 entirely of your report. The panel will not allow comments on evidence tendered in these proceedings or comments on how your legal analysis would apply to the facts of the present case. The panel will, however, allow answers and comments about the general legal standard that you believe is applicable and relevant to a claim of whistleblowing. This is the gist of our decision as regards to your anticipated evidence. Mr. Cadman, keeping in mind what I just said, the floor is yours.
Your Honour, just one additional point. I know that the SBO had objected to paragraph 18. I have no objection to the words between the two commas being taken out. That does refer to some of the same matters that Your Honour has just discussed.
All right.
It doesn't affect Ms. Myers' testimony.
No, only in the admissibility of the report. I understand. And I understand also, while we're on the subject, in your response to the initial report, Mr. Potch, you made no objections to her expert status, and I take it you still do not. Is that correct?
Yes, Your Honor, that's correct. And pursuant to the trial panel's communication yesterday, we also consulted with counsel for Mr. Haradini, and we confirmed as much. We, of course, noted that while we may challenge the credibility in relation to certain aspects, we are not charging the expert's qualifications as an expert as such.
So I take it some of those proposed exhibits that you had that dealt with her expertise are no longer necessary. Is that correct?
Your Honour, I will not be referring to any of those exhibits or seeking to tender them into evidence, as there's no challenge to qualifications as an
Thank you very much for your cooperation on that, both of you. And now you may proceed.
Your Honour, also, Ms. Myers has requested, just so that there is no confusion as to what she can and can't say, I appreciate Your Honour has just read out the paragraphs, but just so that Ms. Myers is mindful as to what she can and cannot say, we have prepared her report with highlighted in pink the areas that she is not to refer to. I have shown to the prosecutor, with Your Honour's leave, I intend to have Ms. Myers have this so that she can be mindful of what she can and can't say.
Any objection, Mr. Potch?
No, Your Honor.
Thank you. You may go ahead and hand it to the usher. This is her copy.
Can I ask, before I begin, that for the benefit of everybody else in the courtroom, that Ms. Myers' report, which says DNH 0313 to DNH 0332, is made available.
Thank you.
And once you have that, Ms. Myers, can I just ask you to confirm that that is in fact your report?
Yes, it is.
Can I ask you to turn to the last page, which is DNH 0332, and confirm that that is your signature?
Yes, it is.
And that your report is dated.
The interpreter's note, could you please pause between question and answer, and please do not speak too fast. Thank you.
Can I ask you to confirm, Ms. Myers, that the date of your report is the 15th of October, 2021?
I don't see the date on here.
Perhaps that could be just shown on the screen.
Yes, I see it. I do confirm.
And can I ask you to confirm that no changes have been made to your report since that time?
Yes, I can confirm no changes have been made.
And apart from the formatting of the report, can I confirm that that is the report that you prepared?
Yes, it is.
Can you confirm that the contents of the report are true to the best of your knowledge or belief?
Yes, I can confirm.
And it accurately reflects what you will say during the course of your examination in chief or your direct examination?
Yes.
Could we put up on the screen DNH 1236 to DNH 1239?
The interpreters kindly ask Ms. Myers to speak up. Thank you.
Sorry, Ms. Myers, the interpreter asking if you could just speak a little bit louder for them. Can I ask you to confirm that that document refers to your instruction as an expert in this matter?
Yes, I can confirm.
Can I ask you to turn to DNH 1238 at the bottom of the page, where it refers to three matters, three documents that you were provided with?
Yes, I can confirm.
Now, due to the limitations of what the court has ruled you're allowed to give your testimony on today, I'm not going to be asking you any questions about those reports, but just to confirm that those are the reports that you received in the compilation of your report.
Yes, I can confirm.
Can I ask you to confirm, even though there is no challenge to your qualifications, I just briefly want to go through a couple of matters with you. What is your current occupation?
I am the Executive Director of the Whistleblowing International Network.
And can I ask if you are also legally qualified?
Yes, I am a lawyer and I'm a solicitor of the Law Society of England and Wales.
And for how long have you been a member of the Law Society of England and Wales?
Since 1998.
And the Whistleblowing International Network, for how long have you been the executive director of that organisation?
Of the formal organization, I have been the Executive Director since 2018.
And prior to your work with the Whistleblowing International Network, can I ask where you were prior to that?
With relation to this field of expertise, I was a legal officer and then deputy director of the Public Concern at Work, a legal advice centre in London, which is now called Protect. I was also the chief executive of the Government Accountability Project in Washington for a year in 2015-16. I have been an evaluator and then a member of the staff of the Council of Europe Group Against Corruption, GRECO. And I have done consultancy both for the UN, the United Nations, as well as the World Bank on whistleblowing. And I was trying to think of some of the things that I've done, but prior to becoming the executive director of the Whistleblowing International Network, I was also doing various bits of work that were done free for the Committee of Legal Cooperation for the Council of Europe. So I was the advisor on the development of the draft recommendation on the protection of whistleblowers. And currently I'm doing a report evaluating the effectiveness for the committee as well to review.
We'll come back to that in a moment. So you've mentioned your area of expertise. Could you just specify, for the benefit of the court, what is your particular area of expertise?
My particular area of expertise is on the legal practice and theory of whistleblowing protection. So as legal director, deputy director of the Public Concern at Work, now called Protect, it was a legal advice centre recognised by the Bar and the Law Society of England and Wales. And we provided advice within the confidential legal relationship to those who were concerned about wrongdoing, and who didn't know whether or how to raise it. We also worked with Parliament, policymakers, regulators and competent authorities in the UK to ensure that they understood the value and importance of protecting whistleblowers and to watch the field. And so in general, that was my beginning of my expertise. And since then, particularly because the interest internationally in the area of whistleblowing has grown, and while at Protect, we were being contacted by civil society organizations and experts from around the world who were interested in this issue. And that is how the network started informally of legal advice centers around the world, and others interested in this issue wanting to share expertise and practice. And so eventually this is what turned into the Whistleblowing International Network, which was formally recognized as a charitable organization in Scotland in 2018. And this is to continue to share this practice and to, one hopes, encourage more of the legal community to provide advice on public interest whistleblowing to whistleblowers around the world, but also to help support the capacity of the organizations that support whistleblowers, which are many at the moment, but we want to encourage more to provide legal and direct support. But there's obviously interest for the organizations that are protecting the independence of the press and journalists, as well as anti-corruption organizations, and those interested in ensuring that information flows around climate change and around food safety and compliance. So the field has not, certainly has not been restrictive in any sense, and it is becoming more of a, a live issue around the world.
I see. You mentioned GRECO, your work with GRECO. That is the Group of States Against Corruption?
Yes.
You mention in paragraph 5 of your report the protection of whistleblowers recommendation. What was your role within that?
So the recommendation is a committee of ministers recommendation. So while I was actually working at the Group of States Against Corruption, that was separate. I was asked while I was there to be the advisor to the Committee on European Legal Cooperation, which was the drafting committee for the Committee of Ministers to draft the recommendation. And so that's what I was doing while I was also at GRECO.
I'd like you to turn to paragraph 7 of your report. You refer to the Government Accountability Project. Could you explain what that is?
The Government Accountability Project is a non-profit organization that has been in existence since 1977. So it is considered one of the longest established whistleblower advice organizations in the world. And certainly the whistleblower protection laws began to be put onto the books in the U.S. before it was really picked up anywhere else. And so that is the organization that has sort of led the field over the years. And I was there for a year doing some work as the chief executive. And they were really begun post the Pentagon Papers, issues around holding government account. They focus a lot on the federal position in Washington advising whistleblowers, but they provide information and advice to whistleblowers all over the U.S. And they take a view very much that whistleblowing is an issue that relates, often is restricted to the workplace, but they are willing and able to support anyone who is raising concerns about wrongdoing and wants some support and advice.
And understanding that a lot of the work that you do is not necessarily in the public domain, to the extent that you're able to, can you explain to the court what you're currently engaged in?
Certainly. So just at the moment, I'm doing a report for the Committee on Legal Cooperation to help them consider how the recommendation has been picked up by member states and whether they want to continue to review it.
And that's the recommendation that you referred to previously, the protection of whistleblowers.
The Council of Europe was one of the first European bodies to really start to examine whistleblower protection within the wider European community. So as the court may know, there are 47 member states of the Council of Europe, and they started to look at, and this was through the Parliamentary Assembly Committee on Legal Affairs, Human Rights and Legal Affairs, and they had a special rapporteur, Peter Omzik, who's a Dutch MP and also a member of the Parliamentary Assembly, looking at that from 2010. Eventually, the recommendations and resolutions of the Parliamentary Assembly Committee urged the Committee of Ministers to draft a legal instrument, and that is what the European Committee of Cooperation was looking to do, which was to draft the recommendation, and that was adopted by the Assembly and by the Committee of Ministers in 2014. So in fact, it was the first sort of pan-European legal instrument. It was relied on and continues to be relied on by as a part of the European acquis, and the European Union since has adopted the directive on the protection of whistleblowers, reporting persons on union law, and that was expected and is expected, and member states are obliged to transpose that into their national legal systems. They were due to do that by the 17th of December of this past year. Many haven't done that yet, but that is now a law in Europe.
Forgive me, I should have asked you this question at the outset, just in the interest of full transparency. Whilst you and I have not met before,
No.
We have worked on whistleblowing cases previously.
Yes, we have.
Do you consider that affects your ability to appear as an independent expert witness in these matters?
I do not.
I want to go on to your level of experience as providing expert testimony. Can you tell the court whether you have provided expert testimony before, with particular reference? I can turn you to paragraph 8 of your report.
Yes, I have. I would acknowledge that not within a formal legal case. So this is my first time providing it here. But I have provided it within the context of parliamentary hearings, certainly into legal parliamentary inquiries into what are legal cases against doctors in the United Kingdom. In particular, I think I put in here the UK's Committee on Standards in Public Life, the inquiry into the activities of the serial killer Dr. Shipman. That was in 2004 when I was Deputy Director at Public Concern at Work, and the 3 inquiries into Doctors Ailing, Neil, Kerr and Haslam. I have provided legal expertise to the Council of Europe's Committee on Legal Affairs and Human Rights, both in 2009 and in 2014, both of which resulted in which I was mentioned in the reports that were adopted in 2010 and 2015, respectively. More recently actually it wasn't that recent, in 2014, in the Canadian inquiry by Honourable Francis Charbonneau, a judge sitting on the Quebec Superior Court who was looking into corruption in Quebec involving the awarding of public contracts, as well as the Canadian Parliamentary Committee who was looking at reviewing the Public Servants Disclosure Protection Act in 2017. So those are much more my formal hearings, but I've also advised governments and other bodies on their whistleblower policies, but also on how they approach whistleblowing protection.
And in individual cases involving whistleblowers themselves, to what extent have you been involved in that process?
Well, certainly when I worked at Public Concern at Work and Protect, I was on a legal advice line, and we worked with whistleblowers daily, giving them advice, and it was particularly important that they had access to early advice so that they were considering what their options were before they raised concerns. We would draft letters on their behalf to employers, and then if they were in positions where they needed to take a claim, we would give them that early advice, and we would offer to work with their lawyers or indeed with their trade union representatives if needed. At the Government Accountability Project, obviously in the position of Chief Executive, I was working with the lawyers and discussing their cases within the legal context. They were the ones taking the cases forward. And in the context of my position as Executive Director at the Whistleblowing International Network, we do advocacy, we talk to and work in support groups that include litigating lawyers and lawyers who can give the advice, but within the context we are supporting them and giving them also and their lawyers advice around the issues that affect them.
Thank you. Now, moving on to your understanding of the various definitions that fall within your area of expertise, what is your understanding of the working definition of whistleblowing?
So I refer in my expert opinion to the definition that David Kay, the Special Rapporteur, the former UN Special Rapporteur on Freedom of Expression and Opinion at the United Nations, uses, and that one is a person who exposes information that he or she reasonably believes at the time of disclosure to be true or to constitute a threat or harm to a specified public interest, such as a violation of national, international law, abuse of authority, waste, fraud, or harm to the environment, public health, or public safety. So that is what I would consider a very sound definition of a whistleblower.
And in your expert professional opinion, is that a definition that is widely used within your field?
Yes.
I want to take you to paragraph 11 of your report. In your opinion, what would you say is the difference between workplace whistleblowing or workplace whistleblowers and those that fall outside of the general employee definition?
So I think this is an important area to discuss. It's one that we are discussing all the time at the international level and within the legal communities. A workplace whistleblower is someone who has come across harm or information that causes them concern, and who has, by virtue of that relationship, is in a particularly vulnerable position. So one of the key aspects of working in this field is to really look at what are the risks that people run when they speak up. And certainly when, for instance, the public concern at work where I worked from 2000 to 2008, in 1993, when it was first set up, what they were focusing on was the concern that there wasn't particular protection for those within work, that their contracts or duties of loyalty were stopping them from properly raising concerns outside the workplace in order to deal with corruption or risk that had a public interest impact. And so a lot of focus has been on ensuring that those whistleblowers, workplace whistleblowers, are able to avail themselves of protection even though they're in this particularly difficult position. This is by no means restrictive in terms of who should be able to raise concerns. And it is also very interesting and clear that organizations themselves, often, particularly larger ones, will make sure that not only they can hear from their own staff, but throughout the supply chains that they run and from the public on matters of their activities where they're at risk at causing harm. So certainly you need to look at what the risks are that the individuals who raise concerns are running and respond within the legal framework to those risks. And clearly workplace whistleblowers need specific protections, but so do the others that do speak up. So often, just to clarify, I will be asked to speak on the range from workplace whistleblowing to witness protection, to journalist sources, and certainly within my network protecting the NGOs that work with whistleblowers.
And specifically the legal protections for non-workplace whistleblowing activities. Just explain that in a little bit more detail for us.
So those tend to be found in other areas of law, and that's where whistleblower protections tend to look at the employment situation, but also data protection, looking at the criminal law, looking at areas of protections in terms of what the criminal system and the civil system provide. So, for example, when the organization that I used to work for was Public Concern at Work was first considering how to promote a law within the UK, they were also looking at having a self-standing tort. So one of the things that has been happening, and I would almost say it's a circular motion, that we're going back to looking at protecting individuals who speak up in terms of defamation, and that is and other parts of the criminal law, because if those who are speaking up are being pursued that way, then those are areas in which we are also interested in ensuring that when they do speak up about wrongdoing, they are able to have a defense.
And to be clear, the advice that you provide that you've mentioned relates to workplace and non-workplace whistleblowing activities?
Yes.
Can you provide an example? I can take you to paragraph 15 of your report, but is that an example of the non-workplace whistleblowing activities?
Yes. Particularly with respect to the network that I'm running, we are working with NGOs, some of whom are organizations that provide support to whistleblowers, and some of them provide legal advice. Others work on campaign and advocacy, so they will work with individual cases, and therefore their ability to do their jobs is clearly one of our key missions, is to protect them and to build their capacity. And so La Plateforme pour la Protection des Lanceurs d'Alerte, PPLAF, is a member of, of the network, and so therefore we will intervene when they need support.
When you say a member of your network, is it the case, and please correct me if I'm getting this wrong, but a number of other NGOs, civil society groups are part of your network?
Yes, so we at the moment have 14 members. Those are organizations that provide legal advice. So they will provide, some of them early advice, some of them will do litigation, but all have a support and advice service where individuals can seek legal advice. The rest of the, and they are part of our governance structure. So they have rights to and must form a majority of our board of trustees. And that's so that the ethos of the network very much are those who work daily with whistleblowers and are dealing with the myriad of issues that arise. The other organizations are organizations working in fields where they have a long-term commitment to the support of whistleblower protection. So they are working in, as I mentioned, the protection of journalists, anti-corruption fields. So a number of Transparency International chapters are part of our organization, and those that protect whistleblowers, protect journalists and are interested in it from a protection of sources perspective. Unions as well, who work with whistleblowers both inside organizations, but themselves can be, many of them are organizations in which they need to deal with whistleblowing separately. So there are a number of those as well.
And speaking generally on the protection to whistleblowers in a non-employer-employee relationship, what are the reporting channels that are available to those individuals?
In a non-employment protection. If they're in a non-employment situation, well, obviously they can still go to organizations that are running the risk and let them know about those risks. But they tend to be ones who will either go to the authorities if they can, or they will go public with their information if they feel that it's not being addressed.
So, looking at a hypothetical situation, if an individual has sought to raise concerns with those organizations, as you've mentioned, and there has been no response, then going public would be an acceptable route for them to take?
Sure. I think what is, but also I think you can go to a journalist and provide it to journalists who then have their own due diligence and ethics around how they will publish the information. And that is one way in which whistleblowers or individuals will get their information out. Obviously, they can do it directly, but that is also, and so they can do that themselves on social media. That has caused an interesting discussion within the media side of things with journalists, but those are the options really on how people go public.
Now, turning to paragraph 16 of your report, I'd like to ask you what is your understanding of whistleblower protection for those who assist or facilitate a disclosure?
From the perspective of the work I do, those are the NGOs that will work with whistleblowers, both within those that provide specific legal advice and those who provide advocacy support and other types of support. Some of them will also do research and be relying on sources. So the facilitators can be those who are certainly within my network, are organizations that are working with whistleblowers. In terms of the framework in facilitation, that can be also within the workplace unions and various parties that are not directly the individuals that are speaking up but are facilitating those disclosures. They can be family members, they can be associates and colleagues.
And if the disclosure is being facilitated by a third party and the first party, the whistleblower, is not known to them, would it still fall within that description?
Yes.
And what source would you rely upon in order to come to that conclusion?
Well, certainly it has come up with, and I would say probably the most obvious examples are still within the journalist field. So journalists are relying on certain aspects of their stories from anonymous sources, and competent authorities as well are increasingly ensuring that they can get information, and some of that information will be where the individual has not identified themselves. For the NGOs that in our network, that will happen certainly as well. And then what that does, I think, is very much put more onus on those organizations to deal with the information.
Now, at paragraph 16, you make reference to two provisions, one of law number 06L085, that's to be found at DNH 0573, DNH 0574. Dealing with Article 8, what does that fit within what you have just described?
So to be clear, the reason that I included those are to show the court that what has been happening in the evolution of whistleblower laws is an extension of the protections. So importantly, in these two laws, you can see that those who are facilitating workplace whistleblowers, it tends to be because the laws tend to be focused on that, are also being protected, but they are not necessarily within those workplaces. And this is, I think, in my opinion, over the years of working with governments and policymakers, our attempts to start to fill the gaps where people are falling through, and it doesn't make legal sense, and it doesn't make sense in a common sense way to policymakers in particular, that those who support whistleblowers are then able to be targeted, because that will have a chilling effect on individuals, the whistleblowers themselves, and other people from speaking up.
And have you or your organization provided advice or opinion concerning the protection of those who elect a specific reporting channel?
Sorry, can you repeat that?
Sure. Have you or your organization provided advice to individuals who elect a particular reporting channel, let's say by disclosing it publicly?
Sure, yes. Certainly, as someone who has the legal framework in mind, it will be, I have advised on all the channels. And I think one of the very important aspects of whistleblower protection generally is to ensure that the channels are the voluntary choice of the individual, depending on the circumstances of the case. One of the other important sort of definitions of whistleblowing really is to ensure the free flow of information for institutional accountability. And therefore, if there are blocks where the information is not able to get to where it needs to go, and ultimately the public has a right to understand what is happening that could affect them, then we will advise on going public and what the ramifications are for that.
And when do you consider it necessary for a whistleblower to choose the public channel in terms of reporting?
So I would, and I assume that everyone can understand that going public is often, we would refer to it as the nuclear option, or the option that is the most difficult to manage. But it is also an incredibly, incredibly important one. So when someone is considering going public, we would certainly consider advising them and asking them to really consider what the other options are. And to ensure, for the sake of accountability, if they can, and again, this really is dependent on the circumstances, that those who ought to be able to address it have the information, and that, but you don't necessarily wait if they're slow or ignoring the information, and you certainly don't continue down that road if they're not handling the information. So there'll be a number of factors that you will take into account around how long you stay at any of those stages. If you can give notice to those who ought to address it and have powers and responsibility to address it. That is important because it shows where accountability is failing. But under most laws, you can go directly to a competent authority, and competent authorities, I think, would be, it's within their remit to address these issues. They want to have the information. And I would just add here that certainly when I've been in different parts of the world advising competent authorities, they will often rely on stories in the press to help them actually understand what some issues are that they might have not had direct information about from the organizations or the sector that they're meant to be controlling. And so those are, the advice really is if there is an alternative route to explore that fully, and but if you can't use that, then going public is your option.
So would it be fair to say that exploring the effectiveness of those other channels would be a consideration in whether it is justifiable in making those disclosures public?
Yes, and it would impact on your reasonable belief about which areas you need to explore and where you should go.
We may come back to the reasonable belief in a moment, but the reasonable belief, is that a factor that you would take into account when making that determination?
Yes.
Now, can you explain what you mean when you refer at paragraph 19 of your report by whistleblowers by proxy?
It is interesting, and again, it's part of this field where the options for where people can reasonably go to raise concerns over the years that I've been working in the field have changed, and some that people would have seen as absolutely available to them 20 or 30 years ago have become less available. And so in terms of who then is the target because they have the information has been changing. And so the people who are supporting whistleblowers or the organizations, particularly in my field of the nonprofit civil society organizations who have the information, more and more they are being targeted because whistleblowers and individuals who are concerned may not feel that they're in a strong enough position, and so they will go to those civil society organizations. They will also go to the press, and journalists again have duties of confidentiality that are perhaps more clearly defined. But NGOs are very careful, certainly within our, from my experience in our field, are realizing that they are now the target, and we are working together so that they aren't alone, because they become, by proxy, by the fact that they're handling the information, the target of retaliation.
And when determining that definition that you've just referred to, what source would you go to? If that helps you, paragraph 21 of your report.
In terms of the source, so the source obviously is my experience working in the field, but in terms of official sources, the most recent Parliamentary Assembly report, which the rapporteur on that was Sylvain Wasserman, the French MP, and that's again the Committee on Legal Affairs and Human Rights, has said that they are urging the Committee of Ministers and the Council of Europe to consider protecting legal entities who blow the whistle or by virtue of their position are quasi-whistleblowers. They've got the information, and they should have that protection should extend to them.
And then before we go on to some of the general principles and criteria, when determining whether a disclosure should be protected, to what extent is the person who is seeking to release that information into the public domain required to verify the accuracy of that information?
So much will depend on their position of knowledge. And so one of the areas that, again, legally has been under some scrutiny, for example, in the early laws in the UK, the term good faith, that you'd raised a public interest concern in good faith. And for most lawyers, good faith is, it means that you did it honestly, not that you couldn't be mistaken, and not that you had necessarily expert analysis. Unfortunately, at the employment tribunals, it often was used to have a long discussion on the motives of the whistleblower, in which case, or the motives of the individual, and it was then used as a bar to even looking at whether or not they'd made a public interest disclosure. And again, if the purpose of the law is to ensure that the public information the public interest information gets to the right place, the idea that you focus on the individual first was undermining the law. And so even though the court in Guha in 2008 said that good faith is one of the requirements or one of the conditions to be reviewed by the court, it is very interesting, and I would put to the court and to you that it's important to take into account that good faith is being removed and has been removed from the legal instruments. So the Council of Europe's recommendation said that all that it should be required is that you have a reasonable belief in the truth of the information to the best of your knowledge at the time. The EU's directive similarly has not included good faith.
And so would it be fair to say that that individual would not be required to conduct extensive analysis if that person had a reasonable belief that would be sufficient?
Yes, and that will be looked at by the courts.
I'd like to take you now to paragraph 28 and onwards, and Your Honours, just for the reference that Ms Myers referred to, Guha, that is the ECHR case which is mentioned at paragraph 26, which is at DNH 0358, DNH 0388. I don't intend to go through it in any detail, but just for the reference.
Thank you.
Now, what are the criteria or principles in order to determine whether a public disclosure should be protected?
So as mentioned, the Guha decision are the ones at the European Court of Human Rights level. Different laws have been looking at it slightly differently. And as I said, nationally and at the regional legal instrument level, good faith is not part of the discussion in the same way. But generally, what the European Court of Human Rights did pick up on, and again, because of my work at Public Concern at Work, I tend to focus on the UK system, but under the Public Interest Disclosure Act, again, some of the issues that will be looked at for whether a public disclosure would be protected, so people would still qualify, would be the seriousness of the information, and as well the detriment to the employer I'll come back to. But in looking at sorry, I'm just making sure that I've got the right order of pages here. Oh, it's been flipped, sorry. We've discussed earlier whether the whistleblower, the individual, had at his or her disposal alternative channels, and that will be explored a bit further about how effective those channels would be or how accessible they would be to the individual. Obviously, the public interest in the information, but in the Public Interest Disclosure Act, it will look at whether or not in disclosing that information, other public interest rights, human rights, were being violated. So again, there's certainly some onus on the individuals to take some, to look at that, whoever is making it public, whether they're writing the article or disclosing it directly. And the authenticity of the information disclosed, again, in most of the laws now, that will be in the reasonable belief of the individual, not as a completely objective exercise that anyone, but for someone in a similar position with a similar experience would have.
So, in assessing the reasonable belief, you would have to look at the individual, that person's particular circumstances, and whether it is reasonable to say that it was a reasonably held belief of that individual.
Yes, at that time.
Now, you refer to 6 principles, and I know that you've referred to the Public Interest Disclosure Act from the UK legislation. I want to take you through those principles, but would you say that the information that you have set out in your report with reference to UK legislation, would that nonetheless represent recognised principles outside of the United Kingdom?
Yes.
So looking at Principle 1, and when I take you through the principles, I would just ask you to be mindful of not comparing it to the facts of this case, but to stick to the principles in general.
Yes.
So looking at principle number 1, where you refer to paragraph 33 of your report, what would you say constitutes the trigger for the protection?
I'm sorry, I don't quite understand what you mean.
Well,
by the
perhaps
trigger.
you could just explain for us what principle number 1 is first.
Right, thank you. So this principle is, again, at the European Court of Human Rights, you're looking at public disclosures. So you're already in that context, and whether or not they had another avenue available to them other than making it public. So that's really the trigger, is having gone public, and whether they were able to avail themselves of other routes.
And again, the trigger for that would be, and correct me if I'm wrong, but even if other options were open to them, it could be argued that they were not practical, they were not successful, and that has necessitated the public.
Yes, so it is where they haven't heard, so they have used it and nothing has happened. They have used it and were found that the information was dismissed, or, and this is where I will compare it to the workplace, but I think these are general principles where you've seen others use those same routes, and again, nothing has happened, or they have been attacked for using them or retaliated against in some way. And that is something that's in the Public Interest Disclosure Act of the UK as well. So it is, this particular clause will very much be, are there competent authorities that are trustworthy, are available to the individual? And that is very, very circumstantial about, and it will require some examination of what that individual thought was the case at the time.
So, in your expert opinion, if I had, in the hypothetical situation, if I had taken this to the state authorities, no action had been taken, or, as you've said, if I've been attacked or criticised for taking certain action, then the public disclosure would then be protected and justified.
Yes, and I would like to say that in my experience internationally, so both as a lawyer who worked in the UK, but being asked to speak about whistleblowing, one of the elements that I've been very aware of is in different countries. So if I'm talking about it, or at least originally 20 years ago, about employment protection in the UK, and I was invited to speak about whistleblowing in Nigeria, and I did do a workshop there, people were talking about physical threats, and they weren't talking about their employment protection. And so depending on the different circumstances in the countries as well, both the policymakers and the individuals will be looking at what are the reasonable, trusted, the routes that people can go. And to mention just that in terms of some of the laws in Latin America, being able to go public or going directly to competent authorities and having a choice of which one you can go to is very keenly part of their whistleblowing laws that cover particularly corruption.
And is it your evidence that those protections against a lack of success or the risk of attack or criticism would be equally applicable in the non-workplace whistleblowing.
Yes.
Now, going to principle number 2, which you'll find at paragraph 34 of your report, how do you explain the public interest in the disclosed information? Again, without making reference to the facts of this case, on a general level, how do you explain principle number 2 in that way?
So you're asking me to look at paragraph 34
Yeah.
and principle number 2, meaning the public interest in the information?
Yes.
So this is, and there is one of the things that has come up in, particularly in European Court of Human Rights cases, is looking at the independence of the competent authority. And in some cases, that will be the judicial system and the prosecutorial authorities. And where there are concerns about how those are running, then obviously the protections for going public will be triggered, and the discussion will be whether or not that the fact that it is so important that these cornerstones of democracy and judicial independence are covered, that it is important that that information gets out, so that all of this is about accountability and institutional competence, good administration, independence. And so this is about being able to shore up these organizations as much as it is to ensure that anything that is undermining them is understood so they can be addressed. And if the information is not able to go public, then the courts will take these into account. So it is one of the aspects of exploring whether or not it was reasonable and whether or not it is in the public interest to go public.
So would it be fair to say that if an individual held a reasonably held belief that a particular institution lacked judicial independence, or that there were concerns as to the independence of a prosecutorial authority, that going public, raising those concerns, would fall within that principle?
Certainly, you need to look at, so you're looking at the individual from a subjective, objective point of view. And so from their point of view and the reasonable belief in their position, if you were a witness or understood that to be the case, and someone in your position, it's very understandable that they would think that, then that is going to provide them with a more protective position.
Now, turning to principle number 3, that's where we deal with the authenticity of the information, which we've dealt with in part. Perhaps you could just expand as to what the principle actually sets out in relation to the authenticity of the information.
So this, again, as my understanding of what the courts have looked at, is in the reasonable belief of the individual, again, that the information that they are revealing is true. Obviously, if they are, I think this is one of the interesting things that has come up in, say, making disclosures to competent authorities, where in some cases the discussion has been on whether or not the individual should have ever made that disclosure, and really the competence and the knowledge rests with the authority. So the individuals have been found to, like a witness, you're not expected to prove the crime in order to be a witness. You provide information to those who can look at it. And so in these cases, you need to look at the person's position, their professional expertise, and someone in that position, whether or not they would think that this was authentic, because they are allowed to be mistaken. But obviously, if they are, they are allowed to be genuinely mistaken about what they do, but it needs to be reasonable.
So if that person had a reasonably held belief that the material in question was authentic, again, going back to what you've already said, they wouldn't need to conduct an extensive analysis of that, but they could in fact be mistaken.
They can be mistaken, and obviously within all societies there's responsibilities on individuals who and how they impart information, but looking at their level of expertise and their position will be part of that exploration in cases where that is being looked at.
Now, moving on to principle number 4, which you go through paragraphs 35 to 37, perhaps you could explain to the court what that principle sets out.
So this is obviously within the context of the Guha case, where there was an employer. In the Guha case, the employer, though, was a public body. So it wasn't looking at just reputational damage. It was looking at the public interest of the service that the employer was providing. And again, this also reveals the importance of a reverse burden of proof, and this comes up particularly in the employment context, that once that you show that you've made a disclosure of public interest information and that there's been a detriment, it switches to the organization that's taking the detriment to show that the detriment was unrelated to the disclosure, because it is very much seen as akin to discrimination law, that you can show that this is what happened, but you can't prove what was in the mind of the employer, and it's only the organization with access to the information they have who can show that they took responsible action and that it was separate and independent from the whistleblowing. And so that's where the reverse burden of proof comes up in the Guha case, because the individual in that case was an employee of the organization.
And staying with principle number 4 just for a moment, what is recognised as a protected disclosure?
This is again going back to David Kay's definition: information that's in the public interest that could cause harm, wrongdoing. So it can be a breach of a law, and it can be a breach of administrative law. It can be any duty that the organization holds towards well, there's obviously in the private sector customers, but in the public sector to the population at large, to the citizenry, and anything in which they think something's been breached or could potentially cause harm, or indeed has caused harm. So it will be looking at in the realm. One of the things to be reminded of, again, the reason to promote public interest whistleblowing is to also prevent harm. So you don't want to wait until there is harm, and that is why laws have covered those who have information where they want to report things where they, in their opinion, can see that harm will be caused, and they will be then protected within many of the employment work-related laws.
And just going back to, as you mentioned, David Kay, the UN Special Rapporteur, in your mind, where does his definition emanate from?
Well, he also looked at the UN Convention Against Corruption, and there is no work-related definition there. They're saying anyone who reports corruption to the authorities needs to be protected, and now this is, again, I know it's not a test, but the explanatory parts of the UN Convention has made it quite clear that it's the indices of corruption as well. So suspicions and indicators need to also be protected.
You're mindful that we are 2 minutes to 11. I do intend to go through the last 2 principles. It's obviously going to take more than 2 minutes to do the next one. It might be a convenient moment to stop.
Okay, we'll break at this time. Please be back at 11:30. We are adjourned. You may escort the witness out.
All rise. All rise.
Be seated, please. Madam Usher, you may bring the witness back into the courtroom. You can be seated, Ms. Myers. All right, Mr. Cadman.
Now, Ms. Myers, before the break, we were finishing up on Principle 4, detriment to the employer. I just want to come back on that just for a brief moment before we move on. Now, you mentioned the reversal of the burden of proof on that. Just explain what that actually means.
This is how it has operated within the workplace whistleblowing laws, because, and it is very much to show that that the information, so it's the prima facie case that the claimant or plaintiff has to make, which is to say that they have raised a concern of information that's within the public interest, and a detriment is followed, and then it will switch the legal burden, the reverse burden of proof onto the employer to show that the detriment was not unfair, and that it was due to a separate and independent basis.
So, to be clear, as you say in paragraph 35, that once a prima facie case has been established of a protected disclosure having been made, and that he has suffered, the individual in question has suffered a retaliation as a result of that, it will be for the employer, and again not straying into the facts of this case, even in a non-employer situation, that entity would have to establish harm.
Yes, either harm or that the action they took is unrelated and therefore is unrelated to having made a disclosure, so it is independently. So for instance, in the EU directive, they've made it clear that you have, that the whistleblowers have civil and criminal immunity, and therefore it will be up to if they are charged or if they're taken to court, it would be up to the organization taking them to court to actually that it's not related at all to the whistleblowing.
And if it is directly related to the whistleblowing activity, they would have to show that they had suffered some harm, thereby the disclosure outweighs,
yes,
on balance, the interest of the employer.
Yes, and the harm test has been most elaborated through European Court of Human Rights jurisprudence. And what the court has said, it has to be in order to for the employer or the organization to show harm, they have to show that it is real and substantive in order to justify that the public interest in the disclosure, the benefit of that, is outweighed by the harm.
And turning to paragraph 36 of your report, conscious of the second sentence has been struck out as we established at the beginning of your evidence. Here is where you're saying that it is up to the court to determine whether public interest in the disclosure outweighs the confidentiality of the information, and that's where that finding would come from.
Yes. Just one other point that I think is perhaps good background is that the Public Interest Disclosure Act, when the organization Public Concern at Work was established, there was no law on public interest disclosures. And one of the elements that they sought a legal opinion on was this common law principle, and again, this may not be relevant, on confidentiality. And the principle that there is no confidentiality in iniquity. And this was again within the employer confidentiality, but what the individual owes, there is no confidentiality if there is wrongdoing. And I think that principle has been applied differently in different cases, but that the general principle applies.
So in circumstances where the employer, in this case another entity, has failed to establish any harm by virtue of that not being evidenced, the individual who has made the protected disclosure would be able to rely on the public interest defence.
Yes.
Now, moving on to principle number 5, and now we've dealt with this to a certain extent. This deals with the reasonable belief. Again, with reference to principle number 5, looking at paragraph 38 of your report, just in very lay terms, how is that assessed?
So it is, you look at the person's subjectively what they thought, but in relation to someone of a similar position with similar access to information, similar expertise.
So would it be fair to look at, from a historical perspective, matters that were relevant to that person, in determining whether there was a reasonable belief? Would these be considerations that would be relevant to your assessment?
Yes.
And as you said earlier, looking at principle 5 and looking at paragraph 38 of your report, the reasonable belief test has replaced the good faith test.
Yes, good faith is no longer part of most of the legal instruments or laws that are being developed and adopted and passed.
And so it would be a reasonable belief, as you say in your report, in the truth or accuracy of the information at the time of the disclosure. That would be what the court would have to assess.
Yes.
Now, finally, turning to principle number 6, paragraph 39 of your report, just talk us through the severity of the sanction, which you refer to at the beginning of 39.
So this refers again to one of the criteria, and just one of the criteria that the Guha court set, which is to look at whether having as one of the elements in looking at the necessity of the interference is whether what level of sanction has been taken and whether it's reasonable in the circumstances for that to have happened. It'll be part of determining the necessity in a democratic society.
And when considering principle 6, would you look at the other principles? You wouldn't look at principle 6 in isolation?
No.
So you could consider what you've already said about principle 4, you could consider the reasonable belief test in principle 5, and then the severity of the sanction in principle 6.
Yes.
Ms. Myers, I don't have any further questions at this time. Your Honours, we seek to tender the expert report into evidence.
Pursuant to the paragraph 4 of the rules of 149, that can only be tendered at the end of the questioning and the cross-examination.
I'm grateful.
So we will hold off on that for the
Certainly.
time being. Mr. Rees, do you have any questions?
No, thank you, Your Honour.
All right. Mr. Podge, you have the floor.
Good morning, Ms. Myers.
Good morning.
My name is James Spotch, and I'll be asking you a few questions on behalf of the SBO this morning and this afternoon. At paragraph 10 of your report, you opine that the best definition of a whistleblower is that provided in a report by a special rapporteur, correct?
Yes.
And you repeated the same this morning, right?
Yes.
Yes, I see that the court officer has already called up your report, and if we can turn to paragraph 10, which starts at the end of page DNH 0318 and goes on to the next page. Yes. And if we go on to the next page, which is the end of paragraph 10, we can see you have a footnote 13, and at the bottom of the page, you are citing to the report of the Special Rapporteur. Is that right?
Yes, that's correct.
And are you aware that in your report and this morning you misstated the definition as put forward by the Special Rapporteur in the report that you cite in this report of yours?
Sorry, that I misstated?
That's correct. That in paragraph 10, where you purport to reproduce that definition, there is an error. Are you aware of that?
No, I'm not.
Okay. In that case, I'd like to call up side by side with this item the Special Rapporteur's report, and that is DNH 0289 to DNH 0312. And we'll have a look at paragraph 28, which is at page DNH 0301. Yes, so we can see, Ms. Myers, on the left of your screen, you'll agree with me that that is the report you're citing, correct?
Yes.
And in particular, you're citing to paragraph 28, which is at the top of the left of your screen.
Yes.
Now, I'm going to read the definition provided in paragraph 28 of the Special Rapporteur's report. And it reads as follows. A whistleblower is a person who who exposes information that he or she reasonably believes at the time of the disclosure to be true and to constitute a threat or harm to a specified public interest. Now, Ms. Myers, if we look at your reproduction or purported reproduction of this definition, we'll see a key difference in our submission is that you use or to constitute. Do you see that discrepancy now?
Yes, I do.
Okay. And can you tell us how that change from the Special Rapporteur's report to yours happened?
That was an error on my part.
So you'd like to correct your report to the extent to reflect that,
Yes.
correct? And let's continue to focus on paragraph 28 of the Special Rapporteur's report for a minute, and that's still at the left-hand side of your screen. We see that the Special Rapporteur noted that international authorities and national jurisdictions adopt a variety of definitions of whistleblowing. You'll agree with that, right?
Yes.
And sticking with the same paragraph, the Special Rapporteur also noted in the present report, the Special Rapporteur adopts a broad definition. You'll agree, right?
I agree.
Again, in the same paragraph, the Special Rapporteur explicitly states that the definition he provides is, quote, for the purposes of the present report. quote, right?
Yes?
And to your knowledge, the definition set out in this special rapporteur report has not been explicitly adopted verbatim in any law that would be enforceable before this court. Is that correct?
I apologize for not knowing exactly what is enforceable before this court, but it has not been adopted verbatim in other laws to do with whistleblowing.
We'll turn to the law enforceable before this court shortly. Before that, I ask whether you would agree with me that a whistleblower or public interest defense has to be based in law. Do you agree with that assertion?
Yes?
And you just mentioned a few moments ago that you're not too familiar with the law that applies at this court. Is that correct?
Yes?
Now, can I ask whether, when you prepared your report, you consulted the law which governs this institution, which is law number 5/L53, on specialist chambers and specialist prosecutor's office?
I did not.
Okay, so you didn't read that law at all at the time of your report,
I did not.
and not after in preparation for this testimony?
No.
Okay. I'd like to call up the law. Madam Court Officer, please. It can replace the documents currently on our screen. And that is at SPOE 00316-093 to 00316-150. And if we could turn to Article 3, which starts at page 316094. I'll just give you a moment to read that, Ms. Myers, and then we'll turn to the next page because it continues over there.
Yes?
We can turn to the next page, Madam Court Officer. And I'd like you, Madam Witness, to read up to subparagraph 4, please.
Yes?
So I will myself read out paragraph 4 because I have a question based on that. And paragraph 4, and just a reminder that I'm reading from Article 3 of the KSC SPO law, and the title of that article is Foundational Principles. Article 3, subparagraph 4 reads as follows. Any other Kosovo law, regulation, piece of secondary regulation, other rule or custom and practice which has not been expressly incorporated into this law shall not apply to the organization, administration, functions, or jurisdiction of the specialist chambers and specialist prosecutor's office. This law shall prevail over any and all contrary provisions of any other law or regulation. Now, I take it that you never read that particular subarticle either, right?
Not until today.
So, having now read this and having it before you, you'll agree with me that no report, law, or legal provision cited in your expert's report is legally applicable at this institution, right?
I do not necessarily agree,
And could you tell me why that is?
because I was providing information based on my knowledge and expertise in whistleblowing law, and I was also referring to the European Court of Human Rights jurisprudence.
But you were instructed in relation to this specific case. You'll agree with that, right?
I was instructed to, in relation to my expertise on looking at whistleblowing.
Was it explained to you that it is in relation to the case against Haradini Application and Haradinaj at the Kosovo Specialist Chambers, or
Yes,
not?
I was.
Right. And you make reference to the European Court of Human Rights, which, of course, as we read in the same article, does apply. And I will agree with you that your report does refer to that, and we'll turn to that momentarily. But your report does refer to the following laws or documents. And again, having read this Article 3, in particular sub-Article 4, you'll agree with me that the law that you cite, the Kosovo law on protection of whistleblowers, does not apply legally before the institution we are in today. Is that right?
Based on reading what you've shown me, not directly, no.
And we can say the same about another law you cite in your report, which is the UK Public Interest Disclosure Act 1998. That can have no application before this court, right?
Those were referred to in terms of my expertise in the area of whistleblowing law and what has informed the Council of Europe recommendation, which in turn has been taken into account by the European Court of Human Rights.
So neither in your report nor now are you suggesting that these laws are somehow enforceable in the case in which you are now testifying, correct?
I am not.
Can we say the same about the Council of Ministers recommendation which you cite, that that has no direct legal application to the case we are in today?
It is not directly applicable except through the European Court of Human Rights jurisprudence.
And that is the European Court of Human Rights jurisprudence interpreting Article 10, right?
Yes.
One other law or form of law you cite in your report is the EU Directive on the protection of persons who report breaches of union law. And that, again, you will agree with me, has no direct application before this court, right?
It was referred to in relationship to my expertise.
Okay, so just to be clear, when you cited these, putting aside for a moment the European Convention on Human Rights and the jurisprudence, you're citing them as principles that you think should be adopted or which are positive or good principles, but you are not asserting, nor do you assert now, that they legally apply this institution. Is that a fair statement?
Yes, it is.
Now, turning briefly to Article 10 of the European Convention on Human Rights, and Madam Court Officer, we could call this up. It is item 104683, 104716. And I'm sure you in particular and many others will be familiar with the provision in Article 10, but we'll just have it for the sake of everyone who can follow. And the page is page 104690, please.
Mr. Potch, slow down just a little bit, please.
I'll do my best, Your Honor. Okay, so we can see Article 10 of the European Convention on Human Rights on your screen. And I'd like to read now from Article 10, sub-Article 2, which of course is referring to the freedom of expression. And it states as follows. The exercise of these freedoms, since it carries with it duties and responsibilities, may be subject to such formalities, conditions, restrictions, or penalties as are prescribed by law and are necessary in a democratic society, in the interests of national security, territorial integrity, or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, for preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judiciary. End quote. And you don't disagree with this sub-article, right?
Of course, no.
We mentioned a little earlier the Kosovo law on protection of whistleblowers, and you agreed that, in particular, because I referred you to the law of this institution, this does not directly apply here, correct?
Yes.
Okay. And just to
Your Honour, of course, that is ultimately a matter for Your Honours, not for a matter to be put in cross-examination.
Agreed. I'll sustain the objection.
Yes, Your Honour, the question was based on the witness having now read the applicable law, and of course, I wasn't purporting her views to override yours in any way.
Yeah, we can read the law.
And, Madam Witness, despite the fact that for present purposes you and I agree this may not apply in this court, which of course, as counsel for Mr. Gucati said, is ultimately for the panel to decide.
I thought Your Honour had sustained the objection to this line of questioning.
I did.
It's not clear to me, Your Honour, what exactly I'm not allowed to say. The witness has agreed that based on the article, this doesn't apply here. So, of course, we're not in any way overriding Your Honour's authority.
She answered before Mr. Rees had an opportunity to interpose his objection. So I sustained the objection. That answer will not be considered by the court, and you can move on.
Okay, understood, Your Honour. So sticking to this law, the Kosovo Law on Protection of Whistleblowers, is it correct that that applies in the context of an employment relationship?
As I understand it, yes.
And that law also refers to a, quote, person associated with the whistleblower, end quote. But in such cases, given that the whistleblower definition relates to an employment relationship, then the person associated also is in a way bound to this employment relationship or related thereto. Do you agree?
Not necessarily. If I can expand.
Please.
This idea of facilitator, and I do agree, I haven't looked at any of the case law under the Kosovo law, but it is now part of the EU directive, is linked to individuals who are raising concerns or may talk to the facilitator, and who the facilitator will help raise concerns. So the original source may be within the workplace, but it's not clear that the facilitator themselves has to be in the workplace.
But would you agree that the person, this facilitator, is assisting has to be a whistleblower as defined in this law, right?
No, I don't agree, or I can't agree if it hasn't been tested. And also, this is within the EU directive. Yes, the original source of the information is someone working for the organization. Whether the facilitator is associated with the organization will likely be the case, but it hasn't been tested.
Okay. Let's have a look at what the Kosovo law actually says. If the court officer could call up SPOE 00316-078 to 00316-092.
Mr. Cadman.
I'm a little bit confused because the prosecution has said that the law is not applicable, and now he's putting questions to the witness based on that law. Just a little bit confused.
Let's wait and see what the question is first.
And if we could first turn to, we are on that page, Article 3, we see under 1.1, it reads, whistleblower is any person who reports or discloses information on threat or damage to the public interest in the context of own employment relationship in the public or private sector, end quote. So this is the link of the whistleblower necessarily being in an employment context, right?
Within the context of this law, yes.
And if we can then turn to the next page, I'd like to look at the definition at 1.12, which reads as follows. Person associated with the whistleblower is the person who assists the whistleblower or can provide evidence related to whistleblowing or any other person that may be harmed due to any association with the whistleblower. So that's the end of the quote. So the link here is between the person and the whistleblower, and as we saw earlier, the whistleblower in this law entails an employment relationship. Do you agree with that?
No, I read that as someone who assists. It's not clear that they're saying the person who assists is within that working relationship, as it could be someone who is any association with the whistleblower. That can be family, friends, other colleagues, or people outside the workplace.
I agree with you there, but what I'm trying to focus on is that the person, the whistleblower, remains nevertheless someone who has to be in an employment relationship, not the person assisting, but the whistleblower.
But it, sorry to be contradicting, but or it can provide evidence related to whistleblowing. To me, there is room here in a definition, and it's only my opinion, that someone who can provide evidence related to whistleblowing isn't necessarily, is independent perhaps of the whistleblower, but is associated in some way with the whistleblower.
Okay, and I'd like to turn to page 316087 of this same law, and we're going to look at Article 20, subparagraph 2. Yes, I'll read it out loud. A whistleblower who discloses information to the public in accordance with this law is obliged to respect the principle of presumption of innocence of the accused person, the right to the protection of personal data, and not obstruct the operation of court proceedings." End quote. So this Kosovo law, as we're seeing here, obliges the person who discloses information to the public to respect, inter alia, the right to the protection of personal data and not obstruct the operation of court proceedings. Do you agree with me?
I agree that is what the Kosovo law says.
And were you aware of this particular provision, Article 20, subparagraph 2, when you prepared your report?
No, I was not asked to examine the Kosovo law.
Is it not correct that this is the same Kosovo law that you refer to in your
Yes,
report?
I reviewed the law and I saw this, but I didn't include it in my report.
Okay, so you were aware that the Kosovo law you cited for other reasons has this provision in relation to the need to respect personal data, not obstruct proceedings, but you didn't include it in the report. Is that correct?
Yes. Yes, sorry, I didn't say that loud enough.
And did you not deem this particular issue of relevance to the overall tenor of your report concerning what constitutes a whistleblower and public interest and what does not?
I reviewed it with respect to the European Court of Human Rights jurisprudence.
Turning to we can take this exhibit off the screen, Madam Court Officer. Turning to the UK Public Interest Disclosure Act 1998, that also only applies to disclosures by a worker and in certain circumstances specified in the Act. Is that right?
Yes, and they have extended it to those who are not in formal employment relationships, but we don't have to get into the detail necessarily.
Thank you for that. Madam Court Officer, could we please call up SPOE 00317-329 to 00317-339. And if we could turn to page 317330, please. And Madam Witness, I'm going to read out from Article 43B3 of this Act, and this is the Act you cite in your report, right?
Mm-hmm. Yes.
So Article 43B3 provides that, and I quote, "A disclosure of information is not a qualifying disclosure if the person making the disclosure commits an offense by making it," end quote. So the UK Public Interest Disclosure Act 1998, which we're looking at, does not afford protection to disclosure of information if the person making that disclosure commits an offense by making the disclosure. Is that right?
Yes.
And again, were you aware of this provision of the law when you prepared your report for this case?
Yes.
Okay. And what is the reason you chose not to mention it in the report?
Again, I was looking at how the European Court of Human Rights jurisprudence examined this for public disclosures. As I was aware, the court wouldn't be examining in detail all the principles of all the laws around the world that protect whistleblowing.
And this can be taken off the screen, Madam Court Officer. I'll turn now to the Council of Ministers recommendation, which you cite in your report. And again, that defines the concept of whistleblower in relation to a work-based relationship. Is that correct?
Yes, and again, just to perhaps just expand the notion, this definition of whistleblower as a word, the word whistleblower tends to be a much more informal word anyway. The Public Interest Disclosure Act, for example, in the UK is called the Public Interest Disclosure Act, not the Whistleblowers Law, and does apply to workplace whistleblowing. But yes, the Committee of Ministers' recommendation on the protection of whistleblowers does look at it within a workplace relationship.
And I'll turn to just one more law or legal provision that you cite in your report, and that is the EU Directive on the protection of persons who report breaches of union law. That's the one you cite in your report, right?
Yes.
And is it correct that this directive only applies in relation to persons reporting breaches of European Union law concerning financial and related issues? And I'm saying financial and related a little bit broadly, but that is the tenor of the provisions it relates to, right?
It relates to provisions to do with those who come across wrongdoing at work. Some of the protections are extended to family and associates and facilitators as well, just to clarify. The individual whistleblower is not always directly employed.
But just for us to be clear, when we look at the material scope of the directive, it is concerning whistleblowing in relation to union law, and then union law as specified in the directive, which is primarily financial and related to financial concerns, right?
No, the EU directive is one, and it was part of the surprise, I think, that they were able, because at first they said there was no legal basis, and then the legal bases are very broad. So it covers food safety, compliance, banking, financial, all the areas, or most of the areas of EU competence.
Yes, let's take a look at this specific provision. If we can call up SPOE 00314-896 to 00314-935. And we'll take a look at Article 2, which is at pages 314-913 and on to the next page. So thank you, Madam Court Officer. So here we can see the first part of Article 2, which says material scope. And I'm reading from the first subparagraph. It says, the directive lays down common minimum standards for the protection of persons reporting the following breaches of union law. I'll pause there. You'll agree with me that because it enumerates them, the following breaches are what this applies to, right?
Yes.
And you can see on this page that we have things such as public procurement, financial services, product safety, transport safety, consumer protection, right?
Yes.
And if we can turn to the next page for the remainder of the same article. We have breaches affecting financial interests, breaches relating to internal market. Is that correct?
Yes.
So you'll agree that this article circumscribes the applicability of this directive, right?
To EU union law, yes.
Thank you, Madam Court Officer. This can be removed. You'll agree with me that information disclosed by a whistleblower has to relate to an actual improper act in order to warrant whistleblower protection, right?
As I explained earlier, it can cover indications of an improper act. It does not have to be, you cannot be in a position of determining that an improper act has happened. You are, in a sense, a witness, and you are ensuring the information is getting out, just in terms of what is covered under these laws.
But there is always the requirement, in your opinion, that it has to relate to an improper act, not to a, let's say, proper act, to take the opposite, right?
Sure, worries and a risk of harm, and worries and risks of improper acts.
And if we look, for example, at some of the jurisprudence referred to in your report and earlier, and I'm thinking of the, I'll pronounce it the way you did, I mispronounced it to myself, but I'm sure you know better, the Guha case.
I'm hoping that that's how it's pronounced, but yes.
We'll agree to pronounce it that way.
Yes.
In the Guha case, it also talks about the wrongdoing which the person intended to uncover, right? So that aspect of wrongdoing is also present in the relevant European Court of Human Rights jurisprudence, correct?
Yes, and wrongdoing is a bit larger than an actual breach that you're certain of. That wrongdoing is areas of concern, and they can include risks of harm.
And you'll agree with me that a public interest is not the same thing as one person's or some person's disagreement with, for example, a policy or law, right?
Again, I do think this is something that courts grapple with to some extent because they can be indications of violations. Yes, I would agree to the extent that if it is a matter of my own personal position and I'm angry at how somebody is acting towards me, that tends not to be covered. But there is a wide range of public interest, and it often is up to the court to determine exactly whether it's in the public interest. The laws try to define it to some extent without being too restrictive, so courts have some room to use their discretion around public interest information.
In your opinion, can one person's or some person's disagreement with a law which is publicly available and known,
Asked and answered.
can it...
Objection, asked and answered.
Your Honour, I haven't even asked the
question has been
question.
put, and the witness has given an answer.
Overruled. Go ahead.
Ms. Myers, I was saying, in your opinion, can one person's or multiple persons' disagreement with a law which is publicly known ever be used to invoke whistleblower protection or public interest protection as such?
That's a big hypothetical. Probably not, but I can't rule it out. Someone's opinion of a law it's unlikely to be the issue at stake, but as unlikely to be covered.
And one of the relevant factors in this is that a law which is public as such, to put it one way, you can't really blow the whistle on something that is known. Is that correct?
I disagree.
Mm-hmm. How about, can you blow the whistle on something that is not denied by the employer or by the institution?
Yes.
You can. And then why would that warrant protection as such?
It is about the risk of harm. It is, for an example, and again, I'm very aware that the Public Interest Disclosure Act does not apply to this court, but one of the principles, and it clearly states that it does not matter if it is known to the employer, because often the individual doesn't know what is known to other people.
And if, for example, the employer has made public assertions about the matter which the whistleblower is making public, is that a relevant factor in your opinion?
That may be a relevant factor for them taking the concern elsewhere. These are factors that come into play in many whistleblowing cases and many cases where there's been an interference with someone's freedom of expression.
And again, going back a little bit on to what we said before, but to relate it to what we're talking about now, there still has to be this element of impropriety, correct, in what is being disclosed?
In the reasonable belief of the individual making the disclosure, yes. Just to be clear, one of the cases that, again, the court may be aware of is the LuxLeaks case, and the original view was that it was not illegal. The tax agreements that were released publicly, and Antoine Deltour was eventually acquitted for making the disclosures to the media, but eventually it was found and examined, because it hadn't been looked at, by the European authorities to have been illegal. So at the time of the disclosure, it wasn't necessarily considered by many people to have been, and many authorities, to have been an illegal practice.
But you're not going back on what you agreed with me earlier, which is there has to be a link to impropriety. I believe you said it doesn't have to be improper, but there has to be a link to or belief in impropriety.
And the individuals who disclosed the information reasonably believed they were wrong to do the practice.
And earlier today, you referred to public disclosures as the nuclear option, right?
Yes.
You also described it as the option that is the most difficult to manage, correct?
Yes.
And you also said you would advise to consider other options before pursuing this public disclosure, aka nuclear option, right?
Yes, in the sense of taking into account whether at that time whether there has been earlier attempts to raise the concern. So it doesn't have to be that every concern you have to raise it elsewhere. In terms of, again, this is my opinion in terms of the advice, because it can go to the reasonable belief of not that it wouldn't be effective if you said, I'd already tried or other people have already tried, and it's not worth trying again with this new information, perhaps.
Would you agree with me that the public disclosure, this nuclear option, should only take place as a last resort then?
I would agree that I would advise that. Doesn't mean that, but I also agree that sometimes you can go directly public.
Reasonable attempts to raise the issue with relevant authorities should be made before going public. Would that be fair?
You are hitting on a point that was a huge amount of discussion and debate during the negotiations around the European Union's directive. And one of the things that was finally agreed is, yes, in principle, there's a lot of encouragement for people because you want, and most people do, you want organizations to work. You want competent authorities to work. So those are the places and people who are responsible and will be held to account. And one would hope would want to learn about issues early enough to address them. But it is very clear that, and the Council of Europe recommendation doesn't have a hierarchy and says it's due to the circumstances. What was in the end agreed in the final version of the EU directive is that you can go to you can go directly to a competent authority, and you can ultimately go directly public. There are some conditions put on that, but you can, that's still available to you. And one of the conditions is where you have either tried to raise it and nothing was done, or it's the risk is high and you need to go directly.
But let's focus a little bit on this, the trying to raise it and nothing is done. In order to merit some form of protection, what you're trying to raise, again, let's think back on what we said, has to have a degree or a link to impropriety, right?
Yes, a concern about impropriety.
Would it be fair to say that the person making a public disclosure, this nuclear option, as you described it, needs to do so in a manner which would cause the least harm?
I would advise that you take care when you make public disclosures.
And why would you advise that?
Again, because you can unwittingly cause harm, but I think, again, courts will look at the individual's position and how much they ought to know or did know about the harm they might cause. Sometimes it will be very much unwitting. And again, those who have expertise, who understand, will be put under, say, professional individuals who understand what the risks are. They will probably be put under a higher responsibility or duties than other individuals. Again, the courts will take it into account.
And this harm which you're referring to, is it correct that that would include, or perhaps most importantly include, harm to innocent third parties?
Yes.
And would the fact that innocent third parties could be harmed by a public disclosure factor into your analysis of whether the person making such a disclosure warrants protection as a whistleblower or as a public interest defense or argument?
Again, if they're seeking my advice, they're seeking some professional advice. So it would be probably a higher level of duty of care that would be involved in decision making. I think one of the things, again, an example that is used, say, from the UK Public Interest Disclosure Act is, revealing patient data to make concerns, again, publicly. Again, some of this, when it shows what the harm is, can be acceptable, but that will be so linked to the facts of each case. But there are duties that you would have to, of course, take into account, and that people have found themselves having to really explain why they made the decision they made. And it will be reviewed by the courts.
And to put it perhaps a little more bluntly or directly, the fact that someone, for example, might be killed as a result of the information which the person is making public, that would matter in your assessment as to whether the person making that information public could invoke a whistleblower defense or public interest defense, would it not?
Again, the risk of harm, there'll probably be two areas or two parties that are questioned on this, is in the reasonable belief of the individual what the harm might be, but also if you are going to say that the interference is justified, then some of that harm side of things would have to be presented by the parties that are arguing that there's a harm, and this has come up in a number of cases.
But you agree that this is a very relevant factor. The damage or potential damage to innocent third parties is a very relevant consideration in the assessment as to whether somebody merits protection. Is that right?
Yes.
Your Honor, if you allow me just a moment to confer with my colleagues, please. Thank you, Ms. Myers. I have no further questions at this stage.
Just a couple of questions, Your Honor. Ms. Myers, when dealing with the question of whether an individual, I think the term we used was the whistleblower proxy, would it fall within that if the information that was being disclosed came from an employer of that entity that had provided that information to a third party? Would that fit within that description that you've referred to?
Yes.
So, and I'm being very careful how I word my question. So if an employee, for example, of a prosecuting authority had leaked information to a third party, and that third party had made those disclosures public, that would fall within that narrow description?
Yes.
Mr. Pace asked you about the applicable legal framework, and I think it's fair to say that much of your report and your evidence focuses on principles that are generally applicable. Would you agree that what you have told us today are principles that are, I don't want to use the word universally applicable, but that they are generally accepted principles outside of a single jurisdiction?
Yes, and just to comment on some of the cases at the European Court of Human Rights have involved those who have been working for prosecutorial authorities, and the issue is very much on the information rather than the fact that they worked for those authorities.
And I asked you the question about David Kay specifically as to where the legal basis for the definition came from. Now, Mr. Pace has taken you through some of the domestic legislation, but would it be fair to say that the legal basis is to be found in the European Convention on Human Rights?
Yeah,
Your Honor, before the witness answers, please. I object to this question. It does not arise from the cross-examination. The report in which that Mr. Cadman is citing was fully available to the defense. He took her through it. So I don't see anything arising from cross-examination here. If it's something that was missed in direct examination, that's not a good reason to address it at the moment. And I also object to the leading nature of the way this question is put. I didn't stand up for earlier ones, but this is also leading.
It is leading, but I'll allow the question. You did bring up David Kay's statements earlier, so you may ask the question. Go ahead.
Sorry, could you-
Rephrase the question, please.
Taking into account what you've said so far, what legal basis do you consider there to be, particularly with reference to the Special Rapporteur's opinion?
So like the European Court, the European Convention on Human Rights, which applies to all persons having rights to freedom of expression and opinion, of which some of the case law has focused on workplace whistleblowers, but other cases haven't. That is one of the bases. Obviously, he looked at the convention in his report, or he mentions it, but he also looked at the United Nations Convention Against Corruption. And in some of the laws I've seen, for instance, in Slovenia, the Anti-Corruption Agency deals with workplace retaliation, but it can also receive reports from anyone around corruption. So if you're looking at it from an informational point of view, everyone has the rights through the conventions and the UN conventions on human rights and anti-corruption to speak up and to raise concerns about wrongdoing, and it's the harm that will be addressed to it's the retaliation or the punishment for doing that will be addressed by different laws, including what are so-called whistleblower laws, tend to focus on the workplace, but some of them have called whistleblowers laws as well. In Latin America, certainly the Organization of American States talks about persons. So it's really the harm to the individuals that you address in those laws to provide particular protections. And workplace whistleblowers have been given particular protections because of their particular positions in an employment relationship. As I said, it's extending.
And Mr. Pace also asked you whether, in your expert opinion, you thought that on the basis of a law, objections to that law could ever form the basis. Now, and again, with reference to reasonable belief, if there was a reasonably held belief that that law was unlawful, could that form the basis for a challenge?
Yes.
And if the concern was on a particular prosecutorial policy, and there was a reasonably held belief that that policy was unlawful, could that form the basis?
Yes.
Objection, Your Honour. It's the same nature of the question just asked. So one question may have arisen from my line of questioning, but a series of questioning did not.
You may finish your question. Overruled.
I'll re-ask the question. If the objection was over a prosecutorial policy that the individual held a reasonable belief that that policy was unlawful, exposing that, could that be protected?
Yes.
Or improper policy?
Yes.
So either if it was unlawful or improper policy, that could fall within the protection?
Yes, it falls within the nature of public interest information.
And just as a final point, Mr. Pace took you through the risk of harm to third parties. Now, going back to what we said this morning in relation to principle number 4, in order for that to be relied upon, would the authority or the entity have to establish actual harm?
Yes, that is, there are some duties and obligations to do for yourself, obviously, as a member of society, to try not to cause harm to other members of society. But depending on what the interference is, the actual risk of harm, if that's being relied on, needs to be shown by the parties who say the harm has occurred if there's public interest value in the information.
And I think that you said that the assessment would differ if you are dealing with a professional rather than a lay individual. Is that fair?
Absolutely.
And just one last question. Mr. Pace has put the point to you on more than one occasion about the impropriety. My question is the impropriety based on a reasonable belief?
Yes.
Thank you, Ms. Myers. I don't have any further questions.
I have just a couple of questions, and some of the other judges may have some questions. I'm merely trying to make sure I understand the totality of your testimony. You cite 3 cases in support of your report. Guia versus Moldova, Bucur and Toma versus Romania, and Heinisch versus Germany. Those are the only 3 cases you cited. In each of these cases, the so-called whistleblower is an employee. Is that correct?
Yes.
You obviously are advocating and have advocated for a broadened definition of whistleblower to get out of just the workplace situation and go to other people, and I understand that. My question is, has that broadened definition of whistleblower been adopted by any domestic or international court in a judgment, to the best of your knowledge and belief?
I'm not trying to be difficult at all, but because there are many laws that will apply to individuals who are not in the workplace, what has been defined or sort of understood, actually not defined, globally around workplace is whistleblowing is often internal to the organization's sources of information. But in terms of again, the extension is happening with the EU Directive and with the Council of Europe recommendations to legal entities. It really is looking at ensuring the free flow of information. So I would say whistleblower tends to be understood, and whistleblower is not a legally defined, tends to be workplace.
No, okay, but they tend to be workplace, but I'm asking you specifically, is there a case in domestic law or international law where this broadened concept has been adopted in language used to adopt it as part of the decision?
No,
Okay.
as far as I know.
That's all the questions I have. Thank you.
Thank you, Judge Smith. I have a few questions starting with the EU Directive, which is Directive 2019/1937. I want to understand the scope of the directive. And we see from Article 3, we can bring it up, but you're probably familiar with it. It reads, and I quote, "This directive shall not affect the application of union or national law relating to any of the following. A, the protection of classified information." And it goes on to refer to some other categories. Now, in the very lengthy preamble to this directive, at paragraph 25, you might recall that it states, quote, "This directive should also be without prejudice to the protection of classified information, which union law or the laws, regulations, or administrative provisions in force in the member state concerned require for security reasons to be protected from unauthorized access," unquote. You said in your evidence there had been a huge amount of discussion and debate about this directive. Do you recall why confidential information was deliberately carved out of the directive?
Well, it's not within my understanding, and I'm not an EU lawyer in particular, but my understanding is that national security is not within their competence. So it's a competency issue rather than trying to carve out particular areas of confidentiality, because the confidentiality, it is saying that you have protections, for instance, civil and criminal law protections, and against, so you can't be seen to be, you cannot be followed through the courts for, say, breaching trade secrets, and it makes particular reference to that, because, and you would have immunity if what you're saying is in the public interest. So they have said that confidentiality and professional business secrecy is not sacrosanct for the law. They don't have competency over national security, so they weren't allowed to talk about it. And I thought there is a paragraph saying it doesn't stop member states from extending it if they so desire, but that's not within
Can I just stop you there for a moment? National security is dealt with in Article 3.2.
Yeah.
I'm talking about Article 3.3.
Of official secrets. Yeah.
Right, they refer to classified information. What's your understanding of the expression classified information?
That it is sort of more classified is information marked as classified, as I understand it, and it's not, again, this is very different, say, from the UK system, which is official secrecy rather than classification. So they may be trying to cover where member states have a classification system and an official secret system.
Okay. If we could move now just to the jurisprudence of the European Court of Human Rights. Do you accept that there is a legitimate public interest in protecting the identities of insider witnesses and police informants?
Yes.
And would you accept that there's a legitimate public interest in protecting the confidentiality of an ongoing criminal investigation?
Yes.
And where an individual is in an employment relationship with the police, such as where the person claiming whistleblower status is a police officer or a former police officer, would you say that the ambit of protected whistleblowing encompasses the public release of the identities of insider witnesses or police informants?
Yes. If you're saying, are you saying that the individual who's releasing it is also within that organization and has those duties?
I would say, could a police officer or a former police officer release to the public the identity of a police informant or a confidential witness?
I think that would be taken very seriously and should be taken very seriously.
Now, where an individual who is not in a relationship of employment with the police or with the law enforcement authorities, generally speaking, is provided with or otherwise comes across information, such as the identities of insider witnesses or police informants, does the ambit of protected whistleblowing cover the public release of the identities of those protected persons?
I'm not saying it should or does in all cases. I think that the issue is and we've had some of these cases, and the discussion will tend to go yes, yes, that's not okay. So yes, I agree that it's not within the ambit, but it doesn't mean it won't sometimes be discussed of whether there was actual harm caused. But I agree that those kind of issues are not often acceptable to the courts as a protected disclosure.
I'd like to move now to the nature of the information disclosed. So I think we can agree that the nature of the information disclosed is a highly relevant factor in determining whether the person is entitled to whistleblower protection.
Yes.
Yes. Now, in the cases that you've relied upon, Judge Smith just referred to the three of them, Guya and the case of Heinze against Germany, as well as the third case. Mm-hmm. Am I correct in understanding that the applicants in those cases disclosed information which cannot be qualified or described as information which reveals the content of a confidential, ongoing criminal investigation?
Forgive me, I am not sure at the time of Guha's disclosures. I think the investigation had been dropped, but it was, those were letters that were discussing a case, and that seemed to indicate that there was interference with the decision about carrying on with the case. So,
right. Now, in paragraph 3 of the decision in Guha, what the court says is that the applicant alleged a breach of his rights as a result of his dismissal from the Prosecutor General's office for divulging two documents which in his opinion disclosed interference by a high-ranking politician in pending criminal proceedings, unquote. Now, throughout the Guha decision, I may be wrong, but it does not appear that the applicant at any stage disclosed information which revealed the content of an ongoing criminal investigation. Rather, his concern seemed to be about political interference in an ongoing criminal investigation.
He disclosed the letters, so I don't know what the details were in the letters, but from what I've read, you could infer what you have said that it wasn't details about the ongoing investigation. I just don't know what the letters themselves substantively said.
Right. And are you aware of any decision of the European Court of Human Rights where the court has found there to be a violation of Article 10 of the Convention in respect of the public disclosure of the identities of protected witnesses or police informants or the content of an ongoing criminal investigation?
I am not aware.
Thank you very much for your answers. Thank you, Judge Smith.
Judge Metro had some questions.
Yes, thank you, Judge Smith, and good afternoon to you, Ms. Myers.
Good afternoon.
As I understand your evidence, Ms. Meyer, you are inviting this panel to adopt a definition of the notion of whistleblower, I will refer to it as the David K. definition, that does not encompass a requirement that the person concerned was employed by the entity to which the information disclosed belongs. Is that right?
I'm presenting my opinion that that is something the court can consider.
But do you accept that such a position, your position, is not consistent with the one that has thus far been taken by the European Court of Human Rights? Do you accept that?
I accept that when they've reviewed cases where there isn't or they haven't found a workplace relationship, they've dealt with it under other aspects of the European. They haven't followed necessarily the criteria of Guha. So they have looked at some of the elements, but not all.
And in fact, all of the cases that have dealt with this claim, the claim of whistleblowers successfully, they are all working relationship cases. I mean, we've heard of Guya, of Butchur, of Heinisch, but there's also a whole series of cases that involve state officials. Is that correct?
Yes.
And of course, I want to also be fair to you there. Are you aware of the guide, the court's guide on Article 10 that is prepared by the registry of the European Court of Human Rights? Are you aware of this document?
I'm aware of it. I haven't read it in detail.
Then I will just put to you, and to be fair to you, of course, this is not a binding document, but it's prepared by the registry of the court, and it says, paragraph 380, it says, firstly, talking of the whistleblower claim, the status of whistleblower necessarily implies a work-based relationship. Now, are you aware that this is a part of the case law of the ECHR, at least as understood by its registry?
No. I do, so there is a case that I didn't put in here, and I'm happy not to refer to it, but there is a case of an NGO, and they were not found to be covered, but there was 6 judge dissent. So it's an issue that's being examined by the European Court of Human Rights.
But so far the law is limited in its application of the whistleblowing claim or defense, to use a loose term, to cases of employment, correct?
Work-related, yes.
Yes. Now, I have a question, and again, if you feel this is not within the scope of your expertise, please say so. But since you are inviting us to adopt the David K. definition, on what legal basis do you propose that it would become applicable to this jurisdiction?
David K. was reviewing the UN Convention Against Corruption, and that is also does not refer to a workplace relationship.
But do you accept, I mean, first, accept it if you can, but do you accept that the Corruption Convention, for example, is not applicable in Kosovo? Are you aware of that?
No, I haven't looked at the list of all those that have signed the treaty.
And you accept, of course, also that it has it doesn't purport to define whistleblowing. It purports to refer to person reporting acts of corruption, Article 33, correct?
Yes. Yep.
It does not provide a definition of whistleblower.
No, and I just again refer to the fact that whistleblower is not. It has been used in some laws, but a lot of laws do not call themselves whistleblower laws. They talk about public interest disclosures, but most of them do relate to work-related protections.
So back perhaps to my question, how would you suggest this definition would become relevant to this jurisdiction? And again, if you feel this is unfair or beyond your expertise, please say so, Ms. Myers.
Yeah, I don't feel that I'm able to comment beyond what I've put in my opinion. That the facilitation of whistleblowing and the fact that the courts will deal with whistleblowing that comes from outside and not necessarily call them whistleblowing would provide the court with some basis to explore this issue further.
And as I understand your evidence, and again, correct me if I misunderstood it, you are inviting this panel to adopt a definition of whistleblowing that does not include a requirement of good faith. Is that correct?
To not look at good faith in the manner in which it was, yes, to look at it from the point of view of a reasonable belief in the truth.
But do you accept again that this definition that you put forward would again be broader in nature than the one that was adopted by the ECHR in Gouya or in Heinz? Do you accept that?
Yes.
Now, assume for a second, and I understand it's not your favorite position, legally speaking, but assume for a second that the requirement of good faith apply. I want to read to you a passage from the Heinisch decision at paragraph 80, where the European Court of Human Rights pointed to resolution 1729 of the Parliamentary Assembly of the Council of Europe. Now, I should perhaps first ask you if you're familiar with the resolution.
Yes, I am.
Now, this is what the court cited. It says, a whistleblower should be considered as having acted in good faith, provided he or she had reasonable ground to believe that the information disclosed was true, even if it later turned out that this was not the case, and provided he or she did not pursue any unlawful or unethical objectives. Now, do you accept this definition to be the one that has been adopted by the court in relation to good faith?
I accept that was in Heinisch. I haven't, so yes, I accept that was in Heinisch, and that I know that that the reasonable belief in the truth is what they focus on, and Heinisch went on to say the issue around not pursuing an unlawful purpose.
But you accept that under the ECHR case law, one of the requirements to the applicability of this whistleblower defense is that the individual concerned would have had reasonable ground to believe that the information they disclosed was authentic and true. Do you accept that?
Yes.
Now, there's another concept, and again, Ms. Meyer, please do not feel that you have to answer something that you think is beyond your expertise, but are you familiar with the notion of abuse of right, and specifically under the European Court of Human Rights case law? Are you familiar with that?
I haven't examined that in great detail, no, in terms of the case law.
But are you aware of what the concept implies?
Yes.
Article 17 of the convention?
Yes.
And is it fair to suggest that this concept, as defined by the court, is that the harmful exercise of a right in a manner that is manifestly inconsistent with or contrary to the purpose for which such a right is granted is not covered by the convention? Do you accept that?
Yes.
And you accept also that this applies, of course, not just to freedom of expression, but among others, to the exercise of freedom of expression.
Yes.
And again, you accept that in order to establish whether a particular conduct amounts to an abuse of right under Article 17 of the Convention, the court scrutinizes the aims which the applicant pursues when relying on the Convention and the compatibility of these actions with the values and purpose of the Convention. Do you accept this to be the test?
I accept that this will definitely be taken into account.
Now, I'm going to go in the business of asking you for a hypothetical, as my colleagues have before. But in your view, Ms. Meyer, someone whose stated purpose would be to discredit, obstruct, or undermine a criminal investigation, would that person be acting in a manner consistent and compatible with democracy and the fundamental values of the Convention, again, in your opinion?
When you say stated, do you mean that the individual stated that that's their purpose?
Yes.
I think that, again, and I'm not trying to say, these things are always need to be examined fully. I think that will be definitely a factor taken into account by the courts.
But I'm asking you, not the courts. In your view and opinion, would someone whose stated purpose is one of those that I've listed, would that person acting in a manner compatible with democracy and the fundamental values of the Convention?
Your Honours, would that not depend on whether the criminal investigation was lawful, unlawful, proper, improper? It would be surely fact-specific and can only be
Mr. Rees,
fact-specific.
if you wish to follow up with questions with Ms. Myers, you will be given an opportunity to do so afterwards. For the time being, could Ms. Myers answer the question as asked?
Your Honour, I do appreciate that it's unusual to raise an objection to a question from the court, but I do, and that's my objection. It does seem to me that the question depends on whether the criminal investigation is lawful, unlawful, proper, improper. It's fact-specific, and the answer can only be.
We'll give you the opportunity to ask those questions. You may answer the question, Ms. Myers.
So I am returning to my expertise and working over the years with many individuals who have wanted to raise concerns. And I think that they may state certain things. That doesn't mean that that is actually their purpose. So I do think that it is fact-specific, that you have to look behind the words to see if that's actually what they were engaged in, because the frustration, and again, this is purely my experience, the frustration of someone at times makes them say things that are not actually accurate about their full position. But again, only in my opinion.
Well, same question, and again, assume it to be the case, but if someone were to disseminate the names of protected witnesses in a criminal case, and again, I'm asking you for your opinion, would that be under the ECHR test, and I'm asking you to apply it, compatible with democracy and the fundamental values of the Convention as you understand them?
Those are aspects that a court would look very seriously at if they were ever to say that the public interest value of the disclosure and the benefit of it was the interference in that right would be based on facts such as you are alluding to.
Now, as I think you've alluded a moment ago in response to my previous question, there might be more than one purpose being pursued by an individual who claims search protection, correct?
Yes.
Now, assume as a hypothetical that a person pursues at once a legitimate purpose, a public interest, and an interest that is not provided by provided protection under the Convention. Let's say someone wants to inform the public and at the same time intimidate someone. For example, what protection would you say that person would receive as a would-be whistleblower? Would it be correct to suggest that the person would only get protection insofar as pursuing a public interest? Or are you saying that he or she would also benefit of that protection insofar as he or she pursues a not legitimate purpose?
Certainly, I agree that there can be more than one purpose. And one of the examples, again, legally and how that has been addressed, but not at the European Court of Human Rights and not within that context, is that the changes to the United Kingdom's Public Interest Disclosure Act, again, workplace whistleblowing, that were made, removed good faith. With respect to being able to have the discussion, so qualifying for protection and having the discussion about whether the information had a public interest benefit, all the rest of it, and whether then to get to the interference, they did put it in respect to the sanction and said that if a tribunal thinks that despite being a protected disclosure, that there was bad faith, they can reduce the sanction, reduce the protection, actually in that case, whatever the court says is your recompense by up to 25%.
Thank you. Those would be my question. Thank you, Judge Smith.
Thank you, Judge Smith. I've just one question for you, Ms. Maas, which is, you said, if I'm not mistaken, you said earlier that whistleblower protection could be granted to persons who reasonably believe that a prosecutorial policy was improper. Is that correct?
Yes.
So my question is, what is your understanding of an improper policy of a prosecution as opposed to an unlawful policy, for example? Can you give us an example of an improper policy of a prosecution?
I wasn't, again, I think these were general, I was responding in a general way to how prosecution and any authority runs itself. There'll be aspects that are legally binding, and there'll be aspects of policy that that are issued and that may not have the same weight. And those policies, if they're improper, so the way that the policies are applying how they fulfill their legally binding duties, then that may come into play.
What I still have difficulties, or what I still don't understand, is what you understand under, or what you understand of an improper policy as opposed to an unlawful policy.
So
So what would be improper from your point of view? For example, if you can just give us an example what your understanding is of an improper policy of a prosecution.
Well, I can only, I guess, refer in my experience to policies from the Crown Prosecution Services in the UK, and there could be policies to do with, it can be any of the policies that the lawyers apply, and it can even be the public interest test, because that is a policy of the Crown Prosecution Service on how they deal with cases, and it is up to the Crown Prosecutor to define those policies. It could be challenged. It would be difficult. But somebody could say that it is not applying it properly.
But maybe I would like to ask another question in this regard. If it's, because I'm still, as I said, have difficulties to understand that, what your understanding is of improper. I mean, the prosecution is certainly bound by law, by legal standards. Is that right?
Yes.
So if the prosecution respects these legal standards, is there room, in your view, for improper conduct when it comes to prosecution?
I
prosecution of cases.
Yeah, I think we're getting into detail of what the information is. It could be that someone is challenging a policy and how the prosecution service operates that they believe would potentially undermine their legal standards, and it could be how they are talking to witnesses. It could be how they're, again, it could be a policy on how they do that, and someone saying, actually, with respect to our legal standard, this does not fulfill it, and that could be considered by a court in the public interest to be improper.
Thank you. Ms. Myers.
I'm sorry, I promised Mr. Reese an opportunity to ask the question that he brought up during his objection.
No, I don't think I need to, given the answers that we're doing.
Right. Now, Mr. Cap.
Perhaps I could be permitted to ask one question in response to what Judge Bart had said as a point of clarification. It's a very short question.
All right, that'll be it, though. One question.
Certainly, and I will try and keep outside of the facts of the case, but when we deal with an improper prosecutorial policy, if we're dealing with a conflict situation and the policy is the reasonably held belief by the individual concerned that the investigation and prosecutorial policy of that entity is discriminatory and is coordinated with individuals from one side of the conflict who are accused of having committed war crimes, crimes against humanity themselves. Could that, in the reasonably held belief, could that constitute an improper policy, prosecutorial policy, that would fall within, potentially and hypothetically, the protection?
Your Honour, before the witness answers, I do object to this question. It falls outside of the guidance we received from the trial panel. I understand there's a distinction between what the parties can ask a witness and what the panel can ask. And in this case, what Mr. Cadman is asking falls outside of what was permissible, which the prosecution also stayed away from. Other than that, the question starts with a reference to improper prosecutorial policy, which, as we heard from the witness, we were unable to determine what her understanding of that is. So I don't know where this would lead us.
I'm going to sustain the objection. The question is almost impossible to answer. It assumes facts that no one else was able to question because of our previous rulings, and we're not going to get into that. So the objection's sustained. And
I understand the ruling, and I don't seek to challenge it, Your Honour's rule, but so that I can have my say, as it were, I do support Mr. Cadman seeking to re-examine on this point. We understand the ruling in relation to paragraph 332 previously, but it did seem to us that the trial panel asked a question specifically of the witness as to an example of an improper prosecutorial policy, and there is an example provided in the witness's report in paragraph 32, which I understand the witness had been led to believe she couldn't refer to and therefore couldn't answer the question for a request for an example. But I understand Your Honour's ruling, that it would have been the submission that I would have made.
well, it isn't that she was led to believe that she couldn't answer. She was ordered not to answer.
No, indeed.
The ruling stands. This question is not necessary. I understood her answer. You understood her answer. We don't need any more.
I was merely trying to assist the court so she could give a proper answer to Judge Bart's question, but I take your ruling.
I think she did her best.
The only point that remains is that we seek to, and now that her examination has been concluded.
Yes, and I believe we previously ruled on most of the paragraphs. We did not rule on 18, which was raised by Mr. Potch, and you have conceded that those 5 words between the two commas, which begin with the word as and end with the word case, will be excluded, and that is the order of the court. Would you please assign a number to the report, Madam Court Officer?
Your Honor, the expert report will receive number 2D6.
2D6 is admitted 2D6 is admitted as modified by the court, and we have a good, just a second, we have a good deal of other stuff that was referred to in today. Are you offering anything else other than this document?
Your Honour, I had indicated that although we're making reference to the European Court jurisprudence, I'm not seeking to tender that. There are, of course, a number of other reports that have been referred to. I know that there's objection by the prosecution because they are not the full reports, which is what I had indicated. We're more than happy to tender the full reports. We hadn't because we were referring just to particular parts of them. It has been notified. The prosecution has very helpfully set out the items with the ERN range and their view. Just to start with DNH.
Excuse me just a second. Mr. Potch, you understand what my question, and you're involved in this as well. Is there some reason you need to have the entire document entered?
Yes, Your Honor. So I need to draw a distinction. For some documents, the objection was both because it's incomplete and because it's irrelevant. For a few of the documents, it's just because it was incomplete. So, for example, if the court were to find that you would like to admit certain laws, we would want those laws to be admitted in a complete version. The defense has disclosed certain versions, for example, of one, I believe it's the Kosovo law that I referred to, which only sets out the front page and the articles specifically referred to by the witness, which in our submission is not the best way to proceed. We have on our presentation queue included the full version. So whether if Your Honours do want, for example, public available laws and jurisprudence admitted, our submission in that case would merely be that it's submitted and admitted in full, so that the record is clear and arguments can be made.
We're trying to avoid entering a 120-page document when only one page was ever referred to.
Yes, Your Honor, but in that case, it depends again what we're talking about. So, for example, the lengthier documents are the ones which go to the witness's professional experience, which I believe the parties are in agreement about will not be sought for admission.
We've already indicated that we are not relying on those documents.
So what would be more helpful is if we can narrow down what exactly we're arguing about.
Let's go through the documents then, one at a time.
So the first document we had, DNH 0001 to DNH 0046. There is no objection to that document. The next document is 0289 to 0312, which is the UN whistleblowing report. There's no objection to that. We then have 0614 to 0723, which is the UN Convention Against Corruption. Again, we don't consider that there's any need to refer to the entire document. Again, we don't need to tender that. It's been referenced, but
I don't believe it was ever dealt with.
Microphone, please.
Or cross-examination, was it?
Not to my knowledge, Your Honor, and this is one of the items we objected because it was only referred to as part of the witness's experience, and also it's not relevant.
We won't be admitting that document.
the next document is the EU Directive, which is at 0556 to 0561. Again, it's an incomplete version. If the court wants a complete version, then that can be uploaded. Then 098.
Just a second. Hold on. This is, how many pages is the EU Directive? Any idea?
It's not an extensive document.
All right. Any objection to that?
No objection to it being admitted in a complete version. Your
Okay.
Honor.
All right. Go ahead.
Then we have 0982 to 0991. Again, more than happy to provide the full report.
Mr. Potch?
I'm sorry, if Council could assist with which this document
It's
is.
the protection of whistleblowers. It's on towards the end of your list.
I have a different ERN for that. Isn't that the same as the
Sorry,
NH 0001?
I do apologise. It is the same document. I do apologise. It's duplicated.
Say it a lot.
Sorry, it is duplicated. It's my error. It's the same document. We don't need to refer to that.
All right.
And then the last one is 0579 to 0580, which is the Public Interest Disclosure Act. Again, we don't need to have the entire Act. It's quite extensive. We only need to have what's already been filed.
On that, Your Honor, we do object. This is one of the instances in which the defense filed only part of the law, but other relevant parts of the law, which I did in fact put to the witness, are not contained in that exhibit. So if the panel would like to admit the law, we would request that it be admitted in full. This is already on our presentation queue, so we don't even need to create a new exhibit. That version could be admitted.
It will be admitted in full.
That's it, Your Honour.
All right, we'll have to have a list of the exhibit numbers then.
Perhaps I can assist the court officer with at least one of the items. The Public Interest Disclosure Act, and of course the defense can verify, which we put in full on our list, is SPOE 00317329. And of course the defense can review and then say if that's correct, that it's in full. So that's one relevant ERN. I could also provide the ERN.
I think the easiest method for doing this would be to, since it's your offer, and you have stated as on all of them that he offered, as long as it's the full document, you have no objection. Send us the list. The court officer will then assign a number, and we will enter an order admitting them. Right?
Your Honour, there's a very brief related matter that I would wish to raise, just for clarification purposes, but I'm very conscious that the witness is sat in the witness box. She doesn't need to be detained any further, it seems to me.
Sorry, Your Honour, just we hadn't included law number 06L85, the Kosovo law. Obviously, that needs to be entered as well. That's 0573 to 0574, but we will, of course, upload the entire law.
Microphone, please.
Thanks for being with us today. Your testimony is finished. The court usher will escort you out of the room.
Thank you very much, Your Honour.
Thank you.
Very briefly, Your Honour, I understand that the discussion that was taking place latterly, perhaps in a different category than the general position, because the witness was called as an expert witness and dealt with some specific instruments. But in the general position, we have understood to be that we do not need to exhibit, and really we shouldn't be exhibiting, law reports, statutory law, that obviously notice is required, and if necessary we can make copies available when we come to deal with them in due course to the trial panel if they're not otherwise available. But there's no need to exhibit, for example, judgments of the European Court of Human Rights. nor a need to exhibit legal instruments that are passed down properly by the Parliament of Kosovo, for example. They're matters that we can refer to in due course when we come to the final trial brief and closing statements without having to exhibit those reports and legal instruments.
The court can certainly take notice of any of those items without having it admitted.
No.
It also could be offered if somebody wishes to. So we're being flexible here, but...
Yeah, I understand. But so in due course, obviously, if we are referring to judgments or pieces of law, we will give notice of them. They'll be in our final trial brief and our closing statements, and if necessary, you can make them available as well to assist the trial panel. But we are not, I understand, I hope correctly, bound to only refer to matters that have been admitted as exhibits.
Correct.
We're not restricted in that way.
Correct. We can look up the
Yes.
European Court of Human Rights decision
Yes.
on a stated case and read it ourselves.
Indeed. Thank you.
So your understanding is correct, Mr. Rees, just to be perfectly clear.
I'm grateful. Thank you, Your Honour.
All right, having heard the parties, the panel admits the expert report in evidence with the exceptions of paragraphs 23, 25, 32, the second and last sentence of paragraph 34, paragraph 36, the second sentence, and paragraph 40. Those are the exceptions to the admission. The panel finds that paragraph 18 I've already ruled upon. Given that this is an expert report, the panel orders the Haradini defense to submit by Monday, 24 January, a redacted version, blacking out or removing the excluded paragraphs and phrases. It is this redacted version that will be admitted into evidence and become a part of the record. The classification will be public, and I believe that's all. And we've got the other evidence dealt with.
Your Honour, just one point of clarification, if I may.
Oh, sure, Mr. Patch.
I understand, at least from the written transcript, that it took down paragraphs 23, 25, but I understand from the ruling that it's 23 until 25.
I'm sorry. You're absolutely correct. I misstated that. It is 23 to 25 and 32. And the others. So I believe we're finished here today. We will be back here on Monday at 8 o'clock a.m. I'm reminding you once again of that. Mr. Cadman, you're on your feet. Do you have something?
Just on paragraph 34, it was certainly my understanding that it was just the first sentence that was redacted, not in... the second sentence.
Microphone, please.
Yes.
Second and last sentence.
I'm grateful.
Okay. So we are adjourned until Monday.
All right.
Oh,
Mr. Bowden's back in charge on Monday.
okay, fine. Thank you for being with us.
All rise.